And then let's look at how we did, what we got. And so you can look at my screen and use that to compare your answers. And let's talk about these things that are typically debits to which party. So the seller's going to pay delinquent real property taxes. What I mean by that is if they never pay 2023 taxes, the seller is fully responsible for that. The seller's responsible to pay the deed preparation fee. They pay to have their deed prepared. The seller pays excise tax, and the seller will typically pay commission unless we're told otherwise. Buyers got a lot more debits. You know, one strategy you might want to take is learning the seller's debits because there's fewer of them. So learning the seller's debits and then knowing anything else is typically going to be on the buyer. So some example of some things that the buyer is responsible for. They're going to pay for their survey. They pay to have their deed and the lender's deed of trust recorded. Buyer pays their lender interim interest. Buyer pays the seller the sales price. Buyer hires the attorney, so they pay the attorney's fee. And then buyer's going to pay for their new title insurance policy that kicks in when they become the owner. Either party could pay HOA dues or this year's real property taxes. Those are things that we prorate, those shared expenses that we prorate. So either party could owe the other. And then the other thing is the home warranty, because that's not customary, that's not the practice. It's totally negotiable who pays for that home warranty if we have one. So that could be up to either. So when we're talking about who pays what, don't forget your cheat sheet that's in the online learning system under the Julie folder. And again, you may want to consider just focusing on the seller because they have the fewer debits. And whatever the seller isn't responsible for, the only other party is the buyer. So how'd we do? Let's see some head bobs back and forth. What questions do I have?
I think this helps out, man, a lot.
Good.
Because
Good.
I mean, I know that the seller, like you said, focusing on the seller, they have a total of 6 on your list. And basically the buyer has, I guess, close to 9, 10, something like that.
That's right,
So,
Howard. And some of that stuff with the seller, I mean, it kind of makes sense. They got to pay off their existing mortgage, right? Buyers, somebody buys your house, they're not going to pay your mortgage, right? So some of these things of the seller's expenses, I think make sense. But you guys review that cheat sheet real quick while I'm speaking of it in case I forget. It's in the online learning system under the Julie folder, and it's called Who Pays for What. At closing, you guys can utilize this until 8:59 a.m. on Saturday morning. I cannot let you have this for your exam. So as you guys are practicing, as we're going through our homework problem on Thursday, I say have this in your hand to help you. As the more you do, the better it gets. Awesome. Awesome. That's right. Print it out and take it with you, or pull it up on your computer, take a picture of it with your phone. So wherever you are and you have your phone, which let's face it, do we ever go far without our phones? So you'll be able to sit in the school pickup line and look at it, or the doctor's office, or in line at the grocery store. Wherever you have a minute, you can look at this. So the reason I wanted to start with the word wall tonight is because, one, I wanted to start with a really good review of who pays for what. But remember that cheat sheet. Remember the who pays for you for what. It's not just pulled out of thin air. It's either by customary practice, like that's just how we've always done things around here, or who pays for what is also spelled out with many of these in our sales contract. So as we go further and further into our sales contract, we're going to see that it talks about the buyer paying for everything related to their due diligence. So anything they could have inspected or tested or investigated, that cost, that debit is on the buyer. It talks about the seller's responsibilities. It talks about prorating. So I think this is a really good segue into where we will probably be the majority of the evening, which is our offer to purchase and contract. We started this last week. We actually got through page 1. I'm not going to go through page 1 again, but I am just going to hit a few of the highlights. The first couple pages are all on the first provision. And the first provision is terms and definitions. We spend the first 2.5 pages just defining things about this contract. So the first thing we have to define is who is the seller. We have to define who is the buyer. We have to define the property, pretty detailed explanation of the property. And then we have to define the purchase price. How is the buyer going to pay? So we started with the sales price and deducted any fees or deposits. May that be due diligence fee or building deposit. Deducting fees and deposits that buyer will pay as part of this contract. And the top line minus everything in between gives us our balance, which, assuming we make it to closing, is how much your buyer owes. So that 100,000 sales price, let's see, 100,000 sales price. We negotiated, I'm just making numbers up, 1,000 in due diligence, 1,000 in earnest money. So if our buyer, I should say, when our buyer makes it to closing, it's like they've prepaid $2,000 and now they only owe 98,000. So the top line minus everything in between gives us the balance due. If we make it to closing, we can almost think of these deposits as like the buyer's down payment. They've already paid $2,000. They don't need to pay that much again. Any questions from the first page? That's as far as we made it last week. Any questions on the first page of our offer to purchase and contract, starting to define things? Before we go on to page 2, do you guys have, I told you to write something down for me last week, so let's make sure you have it written down. And when it comes to contract, the question that you need to be asking yourself on the regular is, what does the contract say? Write that down. What does the contract say? Because there's a really good chance the answer to your question is in this contract. So before we go to page 2, I just want to remind us about what the contract says, that the due diligence and the earnest money is due. The contract tells us that the due diligence fee is due on the effective date. We will define the effective date in just a second. Then we have initial earnest money, which the contract says is due within 5 days of the effective date. So we have due dates of when the due diligence fee and the initial earnest money is due. So the question on the table is, what if the buyer is late in delivering the due diligence? What if they don't deliver the due diligence on the effective date? What if they don't deliver the earnest money within 5 days of the effective date? Top of page 2 addresses that. Should the buyer fail to deliver either the due diligence fee or the initial earnest money deposit by their due dates, or should any check paid by the buyer be dishonored for any reason? If it's dishonored, that's a fancy way of saying it bounced. There weren't enough funds in the bank to cover it. So we're addressing the situation. Due diligence or initial earnest money is late or they bounce. The buyer shall have one banking day after written notice to deliver a cash official bank check wire transfer to the payee. The payee for the due diligence fee being the seller. The payee for the earnest money being the escrow agent. It's the person we wrote the check to. So this is what's up. Those, Celeste, yes, your book is out of date. Everything in your book is out of date. So what we have is the current. The online learning system always has the current. It's what I hate about these hard books. As soon as they print all those out, something changes, like the forms. I hate they put the forms in the books. Don't look at the forms in the books. So we got a situation where the checks bounced or the buyer didn't deliver them on time. The seller is sending written notice to the buyer to deliver readily available funds, cash, official bank check, wire transfer, electronic transfer. You will notice personal check is not an option here. Your first check to me already bounced. I don't want another one. So the seller provides written notice that starts the chain of events, in which case the buyer now has one banking day to deliver readily available funds. If the buyer does not deliver those funds, then the seller shall have the right to terminate. So having that due diligence late, having that earnest money late, you got to have that written notice. The seller has to send a written notice that starts a chain of events of one banking day. If the buyer doesn't deliver in one banking day, the seller shall have the right to terminate. Does that mean that they have to terminate? No, but they have the right. Seller shall be entitled, if they do terminate, to recover due diligence along with the earnest money deposit, paid or to be paid in the future. Seller can seek remedies under paragraph 23, which is our breaching paragraph, 23. This is something that comes up a lot in the real world, you guys. I mean, the effective date, it's after 5 o'clock, right? Banks aren't closed or banks aren't open. If you and I are negotiating this thing at 5:30, 6 o'clock at night, 7, 8 o'clock at night, I'm not going out. I don't know. It's cold. It's wet out there. I'm not going out. I'm probably not delivering this thing on the effective date. I'll get it to you tomorrow. If that's not satisfactory to the seller, then they send me written notice. And now my buyers have one banking day to deliver it, which is my plan anyway, right? Because I'm not going out tonight. Banks are closed already. It's been my experience, as long as we communicate, as long as the agents know what's up. But if there's an issue, then we just need to enact the provision. What does the contract say? Enact that provision at the top of page 2 that addresses these situations. There is a form that pretty much takes that paragraph and puts it in bullet point, word for word. The seller can use that to provide written notice, but just note the contract says written notice. So it could be an email, it could be a text, whatever, as long as it is in writing. Some of your BICs say, hey, if they make a form available, then why not use it? Some may say an email suffices. The contract just specifies written notice. This blue note is telling us that if the parties agree that the buyer will pay any fee or deposit by electronic or wire transfer, seller agrees to cooperate in effecting such transfer, including the establishment of any necessary account, providing any necessary information to the buyer. The buyer will be responsible for additional costs, if any, with such transfer. Questions on that? There you go. Still defining things. Up next, we're going to define the earnest money deposit. The initial earnest money deposit, the additional earnest money deposit, and any other earnest monies paid or required to be paid, collectively known as the earnest money deposit, shall be deposited promptly and held in escrow by an escrow agent. The earnest money deposit will be credited back to the buyer at closing. So the buyer gets a credit for their earnest money at closing, credit the buyer. Or disperse as required by this contract. In other words, if we terminate. Then we define the escrow agent. The escrow agent is going to be the one that's holding the earnest money deposit. The earnest money has to go in a trust account held by an escrow agent. Some of you may join a firm, a real estate firm that has the escrow account. If not, then we're going to let the closing attorney act as the escrow agent. But we need to identify who that is. Buyer and seller consent to disclose by the escrow agent of any material facts pertaining to the earnest money deposit. The name we put in here is the name of the firm, either the real estate firm or the law firm. Don't put the individual unless that's the name of the firm. It's not Julie that's holding it, it's ABC Realty that's holding it. This blue note is addressing if the earnest money is in dispute. So let me talk about that first before we look at the blue note. If we terminate, the contract's pretty clear about what happens if we terminate. If we terminate within due diligence, the buyer gets their earnest money back. If we terminate after due diligence, now the seller gets it. It's in here in the contract, we'll see that. However, understand you guys, if we terminate, what happens to the earnest money isn't automatic. The parties, both parties have to agree to release the earnest money. The escrow agent is just an impartial third party that's holding this on behalf. They can't make decisions about what happens to that money because it's not their money. So if either party does not agree to release it, now the earnest money is in dispute. So in the event of dispute between buyer and seller over the earnest money held in escrow, a licensed broker, an escrow agent, if not a broker, is required to retain the earnest money deposit in their escrow account until they've received a written release from the parties consenting to its disposition. If at any point, or at some point, I should say, at some point, the escrow agent reaches the point, I've contacted you 3 times, for example, and you guys still haven't agreed to release this. So at some point, the escrow agent has the right to send that disputed earnest money to the clerk of courts and let the two go downtown and hash it out. So if the two can't agree to release it, the escrow agent can't make that decision. At some point, they release that disputed funds over to the clerk of courts. And I just recently learned if the two don't go hash it out, after X amount of time, the clerk of courts will turn it over to the state and let the state have that money. So I guess you have a choice. Either let the other party have it or you give it to the state. But if we don't release it, they'll eventually figure out what to do with it. This is regulated by North Carolina General Statute 93A12. You don't need to know that, but it's good that we have references in our contract. So if you're ever in this situation, one of the first things I would do is Google NCGS 93A12 and see what the law says about it. When we're done with the contract, we're going to come back and say a little bit more about earnest money. So we'll talk about the dispute again, if it's in dispute. I don't know why this is in all bold. What do y'all tend to think when it's in bold? Like somebody's yelling at you, right? Yeah, yeah. So I don't know why this is in bold, but here we are. The parties agree that a real estate brokerage firm acting as an escrow agent may place the earnest money deposit in an interest-bearing trust account, and that any interest earned shall be dispersed to the escrow agent monthly in consideration of their expenses when working with the escrow account. So this is a common question, interestingly enough, that I get in pre-licensing. I love where y'all's mind goes. Can I keep the earnest money in an interest-bearing account? And the answer is, as long as the parties agree to it in the contract, yes. And in standard form 2T, the parties agree that it might be in an interest-bearing account. Now we define the effective date. There's two things that have to happen in order to make up the effective date. The effective date is the date that the last one has signed the offer or counteroffer of any, and two, such signing is communicating to the party making the offer. So the effective date is what we previously has discussed as our contract formation. I need two things. I need acceptance and I need communication of acceptance. Most of the time, this will happen on the same day. But if you're negotiating late at night, it might be that it's signed at 11:55 and communicated first thing the next morning. So the effective date then would be tomorrow. We have to have both pieces, acceptance and communication of acceptance. And that lets us know the effective date of the contract, when the due diligence is due. The parties acknowledge and agree that the initial lines at the bottom of each page are merely evidence of their having reviewed the terms of the page. Complete execution is on the signature page that we will see in just a second. So I'm going to go back up so we can see what we're looking at here. The bottom of each page has a place for the buyers and sellers to initial. If they skip an initial, the contract is still valid. This does not affect the validity of the contract. This is just saying we've looked at page 1, we've looked at page 2, we've looked at page 3. What matters, what makes this a contract, is the signature of all parties at the end. Initials don't mean anything in a court of law. Then we define the due diligence and the due diligence fee. So first off, what is due diligence? Well, standard form 2T says due diligence is the buyer's opportunity to investigate the property and the transaction contemplated by this contract, including but not limited to the matters described below, to decide whether the buyer, in the buyer's sole discretion, will proceed with or terminate this transaction. The whole point of due diligence is for the buyer to learn as much as they possibly can. Inspections, investigations, tests, surveys, loan approval, and to decide, based on their sole decision, if they want to proceed with or terminate this contract. The due diligence fee is a negotiated amount, if any, paid by buyer to seller for the buyer's right to terminate this contract for any reason or no reason during the due diligence period. The due diligence fee, the buyer is paying for the right to terminate. And should they exercise their right to terminate because the buyer paid and the seller accepted, the seller can't go after them in a court of law. The seller has to accept that the buyer has exercised their right to terminate, and they accept it by negotiating and agreeing to that due diligence fee. Note that this says a negotiated amount. There's no, and listen, as new agents, I get it. You guys are struggling out there to find a formula. How do we calculate due diligence? Is it a percentage of the purchase price? Is it so much per tax? Whatever. You guys really want a formula. But guys, it's all negotiable. If your buyer really, really, really wants his home, they're probably willing to put up more due diligence. If they're not serious or they're not willing to lose anything, they may not put up as much. It's a negotiated amount. Y'all want to know what the Real Estate Commission says about this? They're so helpful. They say the due diligence fee is whatever the buyer is willing to offer and the seller is willing to accept. G. Thanks. It's all part of the negotiations. Different markets bring in different due diligence fees. If it's a buyer's market, we're generally not seeing as much due diligence. Anybody try to buy a house about 4 years ago during the pandemic? Due diligence fees were through the roof. I was hearing about 5-digit due diligence fees. Unbelievable. But that was the market that we were in. And if you wanted your buyer to be competitive, they had to up that game. I mean, y'all, we talk about multiple offers. Seriously. Had a teammate put a listing on the market over the weekend. She got 45 offers. Somebody's got to win that, right? And nothing talks louder than money. So if this is something your buyer wants, if it's a highly competitive market, then we talk to them about the importance of due diligence. So negotiated amount, by the way, is zero an amount. If the buyer offers zero and the seller accepts zero, we have negotiated due diligence fee in the amount of zero. It's whatever the buyer's willing to offer and the seller is willing to accept. Another common misconception is that the buyer is paying the seller to take their home off the market so the buyer can conduct their inspections and investigations. And that's not true. The seller can leave their home on the market. The seller can allow showings. The seller can accept a backup contract. That's one of the forms that we will look at. The buyer is paying for the right to terminate for any reason or no reason. Comments on that?
You might want to tell some individuals that's given information that, you know, the due diligence fee itself, along with whatever everything else you mentioned, is for the seller to take it off the market and for them to be able to do all those necessary steps to see if they want to accept or terminate that offer.
I agree, Howard. A lot of people have that misconception. You know what I have to say about it? What does the contract say? Does the contract say buyer's paying the seller to take their home off the market? Nope. The contract says the buyer's paying the seller for the right to terminate. So if the buyer terminates, I mean, check it out. Any reason or no reason at all. They could have a really bad home inspection and say, my goodness, I'm not dealing with this. They literally could wake up the next day and go, nah, I don't want to buy this house. They can terminate for any reason or no reason at all. They're not going to get their due diligence back because that's what they paid for, was that right to terminate. Thank you, Howard. Blows my mind. As a listing agent, I would get call from my buyer's agents. I see, you know, accepting backups. I see, are you still allowing showings? Well, yeah, because I follow the instructions of my principal. my seller, not the other agent. I don't work for the other agent. I work for my seller. And if my seller still wants showings, if my seller wants a possibility of a backup, then that's what we're going to do. The due diligence fee shall be the property of the seller upon the effective date. So again, the contract tells us when it's due. So the seller upon the effective date, and shall be a credit to the buyer at closing. So we've just told the buyer the earnest money deposit will be credited back to you. The due diligence fee will be credited back to you. Due diligence fees are non-refundable, except in the event of material breach of this contract by the seller. Or I'll sum that up, a couple other provisions. We're going to see a few places in the contract where where the buyer may get their due diligence fee back. But the number one reason why the buyer may get that back is if the seller breaches. And there's a few other reasons scattered in here that we'll talk about. Anything else that I want to say? Basically just addressing, again, we can have zero and still have a legally binding contract. It doesn't affect the purchase or the sale. The due diligence nor the earnest money affect the validity of the contract. So we could have neither for both and still have a valid contract. Remember, we talked about our 5 musts that the judge is looking for the validity of a contract, and not a one of those musts was earnest money or due diligence. So you can have a valid contract. You can have a legally binding contract without either amounts, whatever the parties agree. So we've talked about due diligence. We've talked about the due diligence fee. So now let's define the due diligence period. This was a change to our contract this past July. We have options now with the due diligence period. We're told to check only one. So I have 2 options here. The due diligence period is the period beginning on the effective date and extending through 5 p.m. on this date. Very specific, this date. Or the period extending for X amount of days after the effective date and ending at 5 p.m. on the last day of the period. The contract tells us later how to count days, but we may remember from TRID that day 1 is always the day after. So we go under contract today, day 1 is tomorrow. And in contract world, a day is a day is a day. Sunday counts, Christmas counts, all the major holidays count. A day is a day. If you're using this number of days, just be very careful and make sure everybody's on the same page about what date. And I'll tell you where agents are using this. I'm not against it, just as long as we all understand what days mean. But you may present an offer to your buyer. You may present an offer on behalf of your buyer to the seller today, and they may not respond right away. They may wait for some other showings. They may wait for some other offers. If I have a date in here, every day the seller doesn't respond, that's chipping away at my due diligence. So instead of putting a date, put a number of days, and then that way I can still get my buyer the 30 days or 45 days, whatever it is that you want. Again, if you're using the X amount of days, please be very, very careful and make sure everybody's on the same page, because not everybody knows how to count days.
Question,
Either
man.
option. Yeah, Howard.
Okay, you talking about the period beginning? You looking at that first check box?
I'm looking at the period extending for X amount of days after the effective date. So either put a date in or X amount of days.
Okay, so that doesn't go with time is of the essence.
Both of them have a time is of the essence. So time of
Oh,
the
okay.
essence for any deadline in this paragraph. May that be a date or a number of days. Who can remind us what time is of the essence is?
No flexibility. It
That's
is
it,
what it
Howard.
is.
It is what it is. That's our drop dead date and time. I mean, they give us a date and they give us a time. Your buyer can terminate up until this day or this number of days for any reason or no reason until 5 p.m. on the due diligence date. If they terminate at 5:01, they are in breach. That's what time is of the essence means. I love that, Howard. No flexibility. It's pretty specific, right?
And you did say that the the clock for the days starts after the effective date, like TRID, right?
You always start counting the day after receipt.
After.
Yep. So we have the effective date. Day one is tomorrow.
Miss Julie,
Yes.
spinning back to that, okay, just for clarification, the effective date. You have to have those two particular elements. You have to have it signed both parties and communicated. Am I correct?
Yes.
Okay, so now if everybody signs communicates today, everything starts tomorrow. But
You got it.
but say for instance, one individual didn't sign, they waiting. Like the seller didn't sign. The buyer's ready, they've accepted, but they ain't signed the paperwork. So now I would use I guess the second check box to say, okay, I have 60 days, after the effective date. So then now I'm in a holding pattern waiting for them to sign, but I still have 60 days.
That's right, Howard, because you don't have an effective date until you have everybody sign and that
Okay.
communication and that acceptance is communicated. So if the seller hasn't signed, we don't have an effective date yet.
Okay.
All sellers and their spouses. Anything else on due diligence? Due diligence fee, due diligence period. On page 3, we are still defining things. I think the first couple pages are the most important because it sets the tone for the whole contract. It helps us understand what we're doing. So still defining things. We got settlement, settlement date, and closing. I got a confession for you guys. I've never been to closing. Guess what? Not a single one of you have ever been to closing, whether you bought your house or you've been with a buyer or seller. What we attend at the attorney's office, we attend settlement. When you get in the real world, you're going to call it closing. Look at your buyer and say, we have settlement next week, and they're going to look at you like you're crazy. You tell your buyer, we got closing next week, and they know exactly what you're speaking of. You guys will, if you haven't yet, you will use it. You say it wrong, because that's just how it is. That's how we talk. But we need to know the contract says that they are a distinction. They are two different things. So first off, to define settlement is the proper execution and delivery to the closing attorney of all documents necessary to complete this transaction, including the deed, settlement statement, deed of trust, or any loan documents, and the closing's attorney receipt of all funds necessary to complete this transaction. So settlement is when our buyers and sellers go to the attorney's office and sign their documents. If buyers and sellers owe any money, they bring it at settlement. We're going to negotiate a settlement date. The parties agree that settlement will take place on this date unless otherwise agreed in writing at a time and place designated by the buyer. You will notice the settlement date doesn't have a time as of the essence. The reason for that, because our blue note is letting us know that delays in settlement just happen. They just happen. Didn't get loan approval. New construction was delayed because of rain. Repairs didn't get fixed in time. Seller got arrested this morning and was trying to get out of jail. Couldn't make it to the attorney's office. Again, I'm not going to say I've heard it all, but I've heard a lot. Pick a reason. Any reason could cause a delay in settlement. Settlement does not have a time as of the essence. Once everybody leaves the attorney's office, then the attorney proceeds with closing. Closing is defined as the completion of the legal process. Who handles the legal process? The attorney. So now they are there doing their things. The completion of the legal process that results in the transfer of title to the property from the seller to the buyer. Closing includes the following steps. Step 1, we have to have settlement as defined above. Step 2 is the attorney's completion of a satisfactory title update. Step 3 is the closing attorney's receipt of authorization to disperse all necessary funds. And then step 4, and the last and final step, is recordation and the appropriate county register of deed, the deed and the deed of trust, which shall take place as soon as reasonably possible for the attorney after settlement. So once we all leave settlement, the attorney puts their finishing touches on everything. It's not a done deal at settlement. We're close, but it's still not a done deal. Things can still happen between settlement and closing. For example, if the attorney finds an issue with the title that they didn't see before, maybe something was added to the title that wasn't there before, they got to get that addressed. If the lender's sending their funds, but they haven't arrived yet, they can't record until they have that money. There's still things that can happen. Everybody works really hard for settlement and closing to happen on the same day. But always have your parties have a plan B. I mean, if the internet goes down, the attorney can't e-record the deed. If the power goes down, right? If somebody hits the power pole out back, then they can't record. So we all try really, really hard for this to all happen on the same day. But understanding it's not done until that deed is recorded. Upon closing, the proceeds of the sale shall be dispersed by the closing attorney in accordance with the settlement statement. If the title update should reveal unexpected liens, encumbrances, or other defects, or if the attorney is not authorized to disperse the necessary funds, then closing shall be suspended, settlement is delayed, and we're once again told to refer to paragraph 12, which is our delay in settlement. Then they throw a red warning at us. The North Carolina State Bar has determined that the performance of most acts and services required for a closing constitutes the practice of law and must be performed only by an attorney to practice law in North Carolina. State law prohibits unlicensed individuals or firms from rendering legal services or advice. Although non-attorney settlement agents may perform limited services in connection with the closings, they may not perform all acts and services required to complete a closing. Closing involves significant legal issues that should be handled by an attorney. Accordingly, it is the position of the North Carolina Bar Association and the North Carolina Association of Realtors that all buyers should hire an attorney licensed in North Carolina to perform a closing. We are a settlement meeting method state, which means we allow settlement agents to handle our closings. Settlement agents is just a fancy way of saying closing attorney. We talked about other states may be an escrow close, different from North Carolina. So this helps your buyers moving from another state that bought a house in New York last year. They didn't have to hire an attorney. They let their escrow agent do it. And they're going to look at you and say, do I have to hire an attorney? In which case you could practically whip this out and read this to them, right? Because the answer to that is yes. North Carolina is a settlement meeting method. One more thing to define. We're going to define a special assessment. This is a charge against a property by a governmental authority or an owners association. In addition to any other regular dues, they're not paid, they could be a lien on the property. So special assessment, either the government or the HOA is improving the property and they're charging the homeowners. The HOA, if it's a condo complex, maybe it's time to repave the parking lot. Maybe we got to put new roofs on the building, so they'll do a special assessment. The government may put a special assessment on. They're going to add sidewalks, street lighting, hook an entire neighborhood up to public water or sewer. They're going to let the homeowners pay for some of that in the form of a special assessment. This blue note is telling us that right now, all we have done is define a special assessment. Later in the contract, we're going to see what both parties' responsibilities for special assessments are. So we're going to see special assessments addressed a couple times.
I have a quick question.
Please.
So at closing, when the attorney is able to disperse the funds,
Mhm.
how do they go about doing that?
So they have all the monies. They've collected the money from the buyer, any from the seller if need be. They have the earnest money. They have the lender's fees, right? They have all the monies and they put in their escrow account because it's somebody else's money. So then they just write checks from the escrow account. They'll write a check to the seller. They'll write a check to our real estate firm, the lender, the home inspector. They'll disperse those funds and just send out checks, write checks.
And they have to do that within is there a period of time?
No, unfortunately, not that I know of. So, Rebecca, what I have to say to you is most attorneys are going to be writing checks like that day or first thing tomorrow morning. Because if they don't, there's a really good chance you and I aren't going to recommend their services anymore.
Okay.
I don't need to get paid like today, but I don't want to wait till the end of the week either. You know what I'm saying? So, and the attorneys are ready to disperse because then they're done. So this usually, they're pretty good. They have unlicensed staff, paralegals to help them with this. So I just kind of brought up a good point, right? You and I aren't getting paid until it's closed. So we leave settlement, and then at some point we're going to get notice from the attorney or the paralegal. My experience, I get an email, short, sweet, and to the point, and it's my favorite email in this whole industry. And that email says, "We are on record." Loosely translate, go get your money. It's time to go pick up your check. And all attorneys record differently. Some may do it once a day. Some may do a couple batches throughout the day. So if you don't know this attorney, if you're not familiar with him, just ask him. When can I come back and get my check? Do not ask for checks at settlement, you guys. You're not going to get it at settlement. We get paid once it closes. Thank you, Rebecca. Other questions on our terms and definitions? Provision number 2 is about our fixtures and exclusions. They start with a big red warning in bold and all caps. Man, this one's screaming at us, right? Warning, the parties should not assume that an item will or will not be included in the sale based on oral or written statement or understanding that is not part of this contract. Buyer and seller should be specific when negotiating what items will be included or excluded from the sale. Remember, the final written word of the contract will prevail over any previous negotiations. So if any negotiations over fixtures and personal property don't make it into the contract, then it doesn't count. So make sure, buyer's agents, make sure you are putting in any personal property that your buyer wants. Listing agents, make sure any fixtures that your seller wants to take are included. Both, well, the seller's fixtures are in the listing agreement, so we can make sure that all jives. Then we're told fixtures are included in the purchase price. All existing fixtures are included in the sale as part of the price, free of liens, unless excluded below. Specified items, buyer and seller agree that the following items, if present on the property on the date of the offer, shall be included in the sale as part of the purchase price, free of liens, unless excluded below. All items listed below include both traditional and smart versions and any exclusively dedicated related equipment and or remote control devices. Our houses are getting pretty smart, aren't they? Everything we have is getting really smart. Everything but me, I feel like sometimes. Everything's just getting a little smarter and a little smarter. And any of these fixtures, whether they be traditional or smart versions, are still considered fixtures. And then we have a fixture list. If you are using standard form 2T, these things are considered fixtures and will remain unless excluded below. Other things that are considered fixtures, a good rule of thumb, if it's nailed, screwed, or glued, bolted or welded, if it's attached to the property in a way that it's meant to be permanent, it is considered a fixture. I've recently heard I love the visual. Pick your house up, turn it upside down, and give it a good shake. If it comes loose, it goes. If it doesn't, it stays. Doesn't that sound like fun? So a good way to define fixtures, what this list just gives us is things that in the past may have been questionable. I've always heard if something made it to the fixture list, it's the direct result of mediation or a lawsuit. So these things pop up, these things come up as things evolve, as things change. The most recent one added, not this version, but last version. Exercise equipment, devices that are attached. When the pandemic hit, we all ran out, bought some kind of exercise equipment. Some of you might have gotten some of those tonal mirrors and attached it to the wall. If you attach that tonal mirror to your wall in a way that is meant to be permanent, isn't that now considered a fixture? Not all sellers agreed with that. Because I don't know what those things cost, but evidently they're not cheap. And they wanted to take their tonal mirrors with them, but they were attached in a way that they were meant to be permanent. So unless excluded, exercise equipment are now considered fixtures. I remember when I started in sales and I had this fixture list handy because buyers asked a lot. Does this stay? They like to point at stuff. Does this stay? Do I get this? Does that stay? And we could do the nail, screwed, or glued, bolted, or welded test, but this list gives us a definitive, that's a fixture, this is a fixture, that is a fixture. So have this list handy. It could answer lots of questions. By the way, this exact same list, word for word, shows up in our listing agreement. So we can have this conversation with the seller at the time we're gonna list it. Seller, I need you to look at this fixture list. And if there's anything on here that you plan on taking, we need to talk about it right now. And the seller's gonna say, oh, we'll look over it tonight after dinner. We know what that means, right? So I always say, I'm patient. I can sit here for 4.5 minutes while you look at this list so we can talk about it. If they're going to take anything, there's pretty much one of two choices. In an ideal world, in a perfect world, the seller will take the fixture down and repair or replace where it was. A buyer will never see it. Take it down before we go list, before I take pictures, and a buyer will never see it. And now I don't have anything to worry about. Do we live in a perfect world? No. You're going to have a seller say, I'm not taking this fixture down until I move the week before settlement. Closing, not going to do it. Awesome. Listing agents, it now becomes your responsibility to make sure that every single buyer that sees that fixture knows when they buy this house, that fixture will not be there. Listing agents, we need to make sure that that is excluded. Again, if the buyer never sees it, we have nothing to worry about. If it doesn't make it in picture day, we have nothing to worry about. I got a little bit more to say about fixtures, but I also want to, let's see, I got a question. Yep. I remember when this came out, when we went from those big box TVs to our flat screen TVs, and they had to update the fixture list because what's a fixture is the brackets, the mounting system for the TV. The TV is not a fixture, but what's attached to the wall is. The TV just slides on. So the buyer's going to look at the 70-inch screen flat TV and say, does the TV come with the house? No, you don't get the TV unless we negotiate it, but you do get the brackets unless the seller excludes them. And I don't understand this because a lot of those brackets are fit for that TV, but think about how those brackets work. Are they attached to the wall in a way that it is meant to be permanent? It is every definition of a fixture. The TV just slides on. I remember when that came out, those big old box TVs, the flat screen TVs. Thank you for that. I do have more to say about fixtures, but like I said, I do want to take a break. I leave you for this at break. Somewhere between now and Saturday morning, I would review the fixture list. Do you hear the words coming out of my mouth? Okay, let's take 10. We come back, we'll talk a little bit more about fixtures. Welcome back. You guys get something good for dinner? Fast dinners, right? Try to plan accordingly. I always do a teeth check before I turn my camera back on too, you know, just to make sure you're not. Welcome back. So our fixture list, and again, you guys, this shows up in the listing agreement. I often think of the listing agreement as a checklist of things to talk about with the seller. So use the listing agreement to your advantage. It's hard to forget something when you're going through that listing agreement. And it's specifically important that we have a conversation about fixtures. And like we said, this is the fixture list if you're using standard form 2T. If you're using a different offer to purchase and contract, then the fixture list may look a little bit differently. But I think we can all agree those fixtures are the things that don't shake loose when you turn your house upside down and give it a good shake. So let's talk a little bit more about fixtures. Yeah. Howard, is that a question?
No, ma'am.
No. All right. Just want to make sure I didn't miss you. Unpairing or deleting data from devices. These are your smart fixtures. Prior to closing, sellers shall unpair any devices that will convey from any personal property devices, such as hubs, intelligent virtual assistants, mobile devices, vehicles, etc., with which they are paired. Sellers will delete personal data from any devices that will convey and restore all devices to factory default settings unless otherwise agreed. Seller's obligation under this paragraph survive closing. So if the seller forgets to unpair from their Ring doorbell, or if the seller forgets to unpair from whatever smart device they had in their home, we go to closing, the seller still has an obligation to do that. We just need to call and remind them. But again, listing agents, as you're going through the home and you start seeing all these smart devices, that's a jump stop for conversation, a jump starting point for conversations for this, to make sure that anything stays. The seller will unpair, delete, and set it back to factory default settings so the buyer can connect when they become the owner and they have access to these smart fixtures. Our blue note, all bold in caps, says any fixture or other item described in subparagraphs A and B above that will not be part of the sale should be identified in D and E below. So fixtures are kind of all over the place, it seems like. We've defined fixtures. We've talked about smart fixtures and traditional fixtures. Now we need to talk about what's gonna go. First off, I got items leased or not owned. The seller can't convey what's not theirs. So if they're leasing something and they do not yet own it, then we need to identify it here. Specifically, any item which is leased or not owned by the sellers, such as antennas, satellite dishes and receivers, appliances, and alarm and security systems must be identified here, shall not convey. Thank you. I just got some hot tea delivered to me. I started it, I just didn't have time to finish it before break, so I'm grateful. It's a hot tea night, isn't it? You know, for example, the CPI security system. Maybe the seller owns that, maybe they're just leasing that as part of their contract. So anything that the seller does not own, any leased or not owned items, anything that's not going to convey, we need to address here. In addition, any leased fuel tanks, we talk all about fuel tanks in paragraph 7D below, shall not convey. And then we have other items that do not convey. This is where the fixtures that the seller wants to take, that the buyer has seen. Maybe they actually saw on the property, or maybe they saw a picture of it in your listings. Once the buyer has seen it, If the seller's gonna take it, then we have to list it as listing agents, make sure it's there as does not convey. If the seller's gonna take any fixtures, seller must repair any damage caused by the removal of any items excluded above in a good and workmanlike manner. Seller will notify buyer upon completion of such repairs and provide buyer with documentation thereof, if any. They can't just jerk the ceiling fan out of the wall and leave a hole in the ceiling. They got to repair it. Maybe they even replace it with another ceiling fan if that's what the seller wants to take. So they have to repair any damage caused when they remove it. And the buyer has the right to verify that upon completion. Buyer's advised to consider attaching the additional provisions addendum if the buyer has a specific request on how they would like the repairs to be completed. Additional provisions addendum is one that we're going to look at in our Fun with Forms day tomorrow. And remember too, you guys, our sales contract is amazing and it's so helpful because it takes the guesswork of whether or not we need a form. It lets us know when we need the form. So you use the contract to help you know when we need an addenda, when we need to attach anything, and we will see that additional provisions addendum tomorrow. Questions on fixtures? Remember, the general rule of thumb, fixtures are meant to stay unless negotiated otherwise. Anything is negotiable. The opposite of fixtures then, personal property. Personal property is meant to go unless otherwise negotiated. The following personal property present on the property on the date of the offer shall be transferred to the buyer at closing at no value. You're not tacking on the price of the personal property items to the sales price. Guys, remember, we are real estate agents. We are not personal property agents. I'm here to sell the house, not the stuff. So any personal property that is negotiated, is agreed upon, is conveyed at no closing. Hands down, without a doubt, the number one negotiable personal property item. Anybody know? Anybody want to take a guess? Rebecca knows. I see head bobs.
Refrigerator?
Fridge.
It is that refrigerator. Refrigerator is considered personal property. And hands down, without a doubt, that refrigerator is the number one negotiable item. It still needs to be in here if it's going to stay. It could be in the MLS advertising. Buyer and seller have verbally agreed 20 times that the seller's going to leave the fridge. But if the fridge doesn't make it to number 3 in the offer to purchase and contract, then the seller is under no legal obligation to leave the fridge. I'd say right behind the fridge is the washer and dryer. Probably the number 2, best guess. Here's the deal, buyer's agents, you want to make sure that you're completing this. You want to make sure you're completing this. Make sure you're very descriptive to describe that fridge, to describe that washer dryer. Let's say the seller has a super nice refrigerator in the kitchen, 2-door stainless steel ice maker, right? It's even a smart fridge. Y'all know there's smart fridges out there. You can get an app for your fridge. When you're in the grocery store, if you can't remember you need milk, you can pull the app up in the middle of the grocery store and look in your refrigerator and see if you need milk. I'm not really there yet. I still have my pencil and paper list on the fridge, but you guys are with me. I mean, fridges get fancy. Buyer's agents, do not put fridge. Put 2-door stainless steel Whirlpool smart refrigerator. Put as much description in there as you can. There have been cases, there have been stories. Buyer's agent puts fridge in here. Buyer moves in after closing, and what's in that space in the kitchen is either a 2-shelf dorm room refrigerator. Did the seller leave a fridge? Did they do what they were contractually obligated to do? They left a fridge. They've also been known to leave, not the one the buyer wants, but the beer fridge from the garage. Did they leave a fridge? Probably didn't have the beer in it, y'all. They're going to take that with them, right? Make sure, buyer's agents, you spell this out. If you need to snap a picture for your documentation, I think that's great. If you can get the make and model number, I think that's great. I would caution you from verbiage such as the fridge that was on the property as of the day of the showing. Could that turn into a he said, she said thing pretty quickly? So please, you guys, be specific. Buyer's agents, be specific to make sure you are protecting your buyer. Y'all want to know the personal best that I ever put in personal property? My ultimate best that I put in personal property. Y'all ready? I got to put this in a legally binding contract. Under personal property, I put Adams Family Values pinball machine. The buyer wanted it, and the seller said, oh, thank God, we didn't want to move that thing anyway. I've never moved a pinball machine, but apparently they're heavy and you got to balance them out. They're not easy. I got to put that in a legally binding contract. That was fun. I was specific, not just any pinball machine, but my buyers wanted the Adams Family Value. Blue note. Any personal property that will be part of the sale shall be identified in this paragraph. All bold, all caps, it was yelling at you. Buyers advised to consult with the buyer's lender to assure that the personal property items listed above can be included in this contract. Remember, all personal property items are at no value. And if this list starts growing, we want the fridge, we want the washer dryer, we want the dining room suite, we want the living room furniture, right? We want the John Deere green tractor. If this list starts growing at some point, the lender might question what it is they are lending money for. Are they lending money for the property? Or is it all wrapped up somewhere that they're lending money for the stuff? If the personal property list starts getting too long, a suggestion is to do an outside bill of sale. Let the two agree to and pay for that personal property. We have to come to an amount. And this has happened so much over the years that this past July, the forms committee actually gave us a form. So I can now say we have a form for that. If you're negotiating personal property, there is an outside bill of sale. The car in the garage is personal property. And if you can negotiate it, we really need to do it as an outside bill of sale. Questions on personal property? So yes, down at the beach, you very well may get a furnished condo. In which case that buyer will probably get a package loan where they're combining real property and personal property. Or they can agree to do an outside bill of sale. But yeah, it's not uncommon down east, especially in a vacation property, for a furnished unit, a furnished condo or unit to be sold. So we have to figure out how we're going to convey that personal property, either a package loan or an outside bill of sale. Maybe up in the mountains too. You might have a cabin or something that is furnished. Thank you for that. Other things on fixtures and personal property or personal property. Remember, the fixture is meant to stay. Personal property is meant to go. If it's going to do the opposite of its intent, it's got to be in here. So then we get into provision 4. You guys may want to make a note. Provisions 4, 5, and 6 are all about the buyer. So buyer's agents, when you're reviewing the terms of the contract, 4, 5, and 6 are their provisions. So 4 goes over the buyer's due diligence process. Starts with a big red warning, all bold, all caps. Buyer is strongly encouraged to conduct due diligence during the due diligence period. If the buyer is not satisfied with the results or progress of the due diligence, buyer should terminate this contract prior to the expiration of the due diligence period unless they can obtain a written extension from the seller. Guess what? The seller is not obligated to grant an extension. We can ask if we can have more time. We need more due diligence time. An offer has been made, so the seller can either accept it, reject it, or counter it. We are in another round of negotiations. If the buyer wants more time, what's something that might make the seller more apt to agree to more time? More money. Money, money, money. If we're asking for more time, your buyer may be expected or requested to put down additional due diligence. Another form we're going to look at tomorrow is our agreement to amend. So if we agree to more time, if we agree to more money, I got a form for that. This takes us back to what we were saying earlier. We go under contract, the buyer pays the due diligence fee. They're not paying the seller to take the home off the market. They're paying for that right to terminate. Although the buyer may continue to investigate the property following the expiration of the due diligence, buyer's failure to deliver a termination prior to the expiration of the due diligence period will constitute a waiver by the buyer of any right to terminate this contract based on any matter relating to the buyer's due diligence. Even though we're out of due diligence, the buyer still may be investigating and learning. They're investigating and learning up until the final walkthrough on our way to settlement. Any repairs that were done, they have the right to inspect those. Understand, the only thing they're giving up at the end of due diligence is the right to terminate. They're not giving up the right to inspect, the right to investigate. So inspections and investigations continue after due diligence. They've just lost that right to terminate. What's the terminology I heard not too long ago? It's an easy exit. The due diligence period is an easy exit. And when due diligence is over, they no longer have that easy exit. Provided, however, following the due diligence period, buyer may still exercise the right to terminate if the seller fails to comply with any of their obligations listed below, or for any other reason under the terms of this contract. And then we kind of go through a laundry list of things that the buyer should consider doing during due diligence. Now, we've seen this list, so I'm not going to spend as much time in this section because we've already talked about this back in chapter 14, the buyer's due diligence process. I am going to hit a few highlights here, though, of course. One of the things the buyer needs to do during due diligence is pursue that loan. The loan process is the longest part of the contract to closing process, which is why we need to get the lender working on the loan right away. It's going to be incredibly rare for the buyer to have final loan approval while we are still in due diligence. But what we're hoping for in due diligence is the lender to send the loan for the first round of underwriting. And when it comes out of the first round of underwriting, hopefully while we're still in due diligence, what it gives the lender is a pretty good idea. Either things are looking good, just submit this, and this document, or things aren't looking good. I don't know if you're going to get loan approval. So we don't have an official word yet, but based on the lender's pretty good idea, the buyer needs to decide if they want to move forward with or terminate. The blue note reminds us that there is no loan or appraisal contingency in this offer to purchase and contract. Buyers advised to consult with their lender prior to sign this offer to assure that the due diligence period allows sufficient time for the loan process and for the buyer's lender to provide buyer sufficient information to decide whether to proceed with or terminate this transaction. Once you guys meet your preferred lenders, you're going to know about how long they need for due diligence, how long they need to take to do their thing. Good. If this is a lender you've never worked with before, call them while you're still writing the offer. Hey, how much due diligence do you need for our buyer? The lender and I both have the same interest, and that interest is our buyer. So how much time do you need if we don't know this lender? Also note, you guys, there's no loan contingencies. If you bought a house 20 years ago, there was a loan contingency. They've done away with that. There are no more. A loan contingency is something like, I'm not legally obligated to buy your home if I don't first get loan approval. So I'm only on the hook to buy your home if I get loan approval. If I didn't get loan approval, I can walk away. We do not have any built-in contingencies. Can the parties agree to add a contingency? Sure, because anything is negotiable. I do not have a form for that. We do not have a pre-printed form for that. So what do we got to do?
Have the lawyer draw one up.
We're going to have the attorney draw one up, Glenn. We're going to have your buyer's attorney draw one up, let them pay for it. Can I draw it up? No. So the loan, get that process going because we know it's going to take the longest. And then the property investigation. The buyer, the buyer's agents representing at buyer's expense, there it is, shall be entitled to conduct all desired tests, surveys, appraisals, investigations, examinations, and inspections of the property as the buyer deems appropriate, including but not limited to the following. So anything, let me go back up just for 1 second. Anything related to the buyer's due diligence process, we are told is going to be at whose expense? The buyer's expense. Debit the buyer for their property investigations, tests, surveys, etc. So what we have listed here is a list of things that the buyer should consider doing. Again, we've already talked about all this, so I'm not going to go through it again. But this gives us a pretty good idea, especially if you're talking to a first-time home buyer or somebody that doesn't really know what to do. This can get them started. Remember, you guys, I'm not the one buying this house. So if your buyer wants something tested or inspected or investigated that's not on this list, our response is, okie doke, let's do it. Never look at a buyer and say, oh, you don't have to worry about that. That'll be just fine. You're not the one buying this house. You're not the one taking on a 30-year mortgage. So we let them decide what tests and inspections and investigations they want. If it's not on this list, we can still do it. Also during the buyer's due diligence, if they have to sell or lease an existing property, I'm not creating a contingency here. I'm just telling the buyers what they need to do about the sale or lease of an existing property during due diligence. So as noted in 5B below, unless otherwise provided in an addendum, this contract is not conditioned upon the sale or lease or closing of another property owned by the buyer. Therefore, if buyer must sell or lease other real property in order to qualify for a loan or complete the purchase of this property, buyer should seek to close on their other property either prior to the end of the due diligence period or be reasonably satisfied that their property will close. There is no contingency. And this is why we're encouraging the buyer to sell or lease that other property while they're still in due diligence. Because if their buyer doesn't buy, then they'll need to terminate. They probably don't have the funds to close unless they do. Can the parties agree to add a contingency? If I don't sell my home, I'm not legally obligated to buy yours. Yeah, they can. It's important. We used to have a form for that, but they've retired it. So if you come across a contingent sale addendum, that form's been retired and we cannot use it anymore. So I do not have a form for this, which means we are once again calling the attorney if we want to create a contingency. Still under buyer's due diligence. Repair improvement negotiations. Buyer acknowledges and understands the following unless the party agrees otherwise. Here it is. This property is being sold in its current condition. Does the seller have to do any repairs? Does the seller have to change a light bulb? No, because what does the contract say? This property is being sold in its current condition. Seller may, but is not required to engage in negotiations for repairs or improvements on the property. Buyers advised to make any repair requests in sufficient time to allow negotiations to be concluded prior to the expiration of the due diligence period. Again, that's what the buyer's doing during due diligence. They're learning everything that they can, including, is the seller willing to fix anything? And if they're not, then the buyer's got to take that into consideration when they're deciding whether or not to move forward with or terminate this transaction. Any agreement that the parties may reach with respect to repairs must be in writing and signed by all parties. The repairs have to be negotiated, agreed on, in writing, and signed, all while we're still in due diligence, especially by the seller. I need the seller's commitment while we're in due diligence. If the seller agrees to do any repairs, we have amended this one sentence. Because now the property is no longer being sold in its current condition. Now it's being sold in the condition that the seller fixes this, this, and this. So once they sign it, it changes the contract, and that's why we need them to sign it while we're in due diligence. The repairs themselves don't have to be complete until prior to settlement. We just have to have it in agreement. And buyer's agents, I don't know if you guys have experienced this yet or not, listing agents. I find it as a listing agent in very poor taste when I get the due diligence repair request at 4 o'clock on the due diligence day. I don't know a quicker way to get a no from a seller than not give them time to think about it, not give them time to talk to their people, their electrician or plumber or whatever the issue is. So buyer's agents, that's addressed here, making any requests in sufficient time to allow negotiations, to allow the seller to think about it, talk to their people if necessary. Of course, the seller could also just flat out say, no. There's no rule that says I can't ask. Even a home's as is. My buyer wants to ask for repairs. I work for the buyer. I work for the seller. Yeah, Howard.
Yes, ma'am. That kind of sheds some light on the situation I'm actually going through currently. I asked a particular buyer to go ahead and put a list together after our showing of all of this discrepancies that she came across, and then that way we can present it when we do the offer to purchase agreement.
So when you present the offer, you're going to ask for repairs?
Yes, because we actually went through a showing.
Oh, nice.
And so when we went through the showing, it was some areas that brought up her concerns.
Sure. Howard, we got a
Yes.
form for that. We can ask for repairs at the time that we're presenting the offer. So we're going to use our additional provisions addendum.
Mhm.
And when we're presenting the offer, we can say, when you're considering my offer, I also want you to consider fixing this, this, and this. The seller can either accept it, reject it, or counter it. So I think that's great. And we'll see that form. Yeah.
Tomorrow? You said tomorrow?
Yep, tomorrow. Fun with forms tomorrow.
Can we attach excuse me, Ms. Julie?
Yeah.
Would I have to rewrite everything, all of the concerns on that form, or can I just attach the form to addendum?
Howard, that's going to be up to your BIC.
Oh, okay.
Yep. Yep. So let me introduce you to the form tomorrow, and then we'll decide. You can take it to your BIC. You can impress your BIC. They're like, I know I can write it up, but how about this form? And your BIC's going to go, wow, Howard. Wow, your BIC. Let's see. Buyer's obligation to repair damage. Buyer shall, again at buyer's expense, properly repair any damages to the property resulting from their activities of them or their agents and contractors. The buyer shall not be responsible for any damage caused by accepted practices, either by the North Carolina Home Inspector Licensure Board or other applicable North Carolina licensed professionals pertaining to appraisers, tests, surveys, examinations, inspections, etc. This repair obligation shall survive any termination of the contract. So all these people your buyer is hiring to do due diligence, if any one of those people, the home inspector, the survey, if anybody damages the property during their inspections, who gets to pay for it? What does the contract say? That is at the buyer's expense. This is the reason why we don't send our buyer to Google to find a home inspector. This is why we come with recommendations and suggestions. Because now guys, you're human, right? So do accidents happen, mistakes happen, of course. But people that you've used in the past, you form that relationship. You can recommend their services. If you don't know anybody just yet, check with your firm. They might have a preferred vendor list. But if anybody that the buyer hires to conduct their tests, inspections, etc., they damage the property, that's going to be at the buyer's expense. Now, there are some things that are considered accepted practices by the boards. So for example, and the one that makes me laugh every single time I see it, I don't know why, but it just tickles me every single time. If the home inspector finds soft or rotted wood, maybe the wood around the door frame or the window frame the windowsill is rotted. Home inspectors like to take lots of pictures and show you that things aren't working, that things are broke. And when they find soft or rotted wood, they take their really big screwdriver and they jam it in there. And then they take a picture of the screwdriver poking out. And that just makes me giggle every time. I don't know why, but it does. Understand, the home inspector did not damage the wood. The home inspector was showing that the wood was damaged. Look, my screwdriver stands straight up in it. If it was good wood, it wouldn't dig in it. It wouldn't go in it. So that's one of those accepted practices that shows in the picture that this is softer rotted wood. Comments on that? Buyer's obligation to repair damage is one that I always see shocked looks when I look up. The buyer's responsible. There was a case not too terribly long ago. I thought of Christmas Vacation. Home inspector went through the attic. I don't think they had a what do they call it? A double bed. What do they call it? Bunk beds? Y'all know Christmas Vacation? I don't think they had bunk beds to fall on. But yeah, home inspector went through the ceiling in the attic. Is that because the property was damaged? Was it already damaged? Well, I don't think that was solid wood. They wouldn't go through it. Seller said the home inspector shouldn't have been up there. As a buyer, if I'm hiring you to inspect a home, I expect you to be up there, and the crawl space and the basement and all those other places I don't want to go. That's why I'm hiring you. So sometimes it turns into a he said, she said, it turns into a debate. Put real estate aside for a second. In general, if two parties can't agree to agree, then the judge will decide for them. There's an indemnity paragraph. If you indemnify somebody, you hold them harmless. So the indemnity paragraph, the buyer's going to hold the seller harmless for things not addressed in the contract. Things can happen. I can't predict the future. My crystal ball is foggy. I can't tell you what's going to happen. But if things happen that happen outside of the contract, the buyer may not be able to hold them to it. They may have to indemnify them. Buyer's right to terminate, provided that buyer has delivered any agreed upon due diligence fee. Buyer shall have the right to terminate this contract. Here it is again, for any reason or no reason. All they have to do is provide written notice of termination to the seller. And we have forms, we have termination forms. Written notice of termination during the due diligence period. If the buyer timely delivers the termination notice, his contract shall be terminated, and the earnest money deposit shall be refunded to the buyer. If the buyer terminates for any reason or no reason during due diligence, they provide written notice to the seller, and they'll get their earnest money back, assuming the seller agrees to release it. It's not disputed funds. The seller will keep the due diligence fee because that's what the buyer paid for. The buyer paid for that right to terminate and get their earnest money back. Last sentence under buyer's due diligence, closing shall constitute acceptance of the property in its then existing condition unless provisions otherwise made in writing. Congratulations, Mr. and Mrs. Buyer. This house and all its problems are now yours. Here are your keys. Closing constitutes acceptance of the property in its then existing condition. This is why that final walkthrough is so important, especially if buyer and buyer's agent have never seen this home vacant. If we're seeing it vacant for the first time, even if we've seen it vacant every time, because the buyer needs to understand that when they go to settlement and they sign and that attorney records the new deed, it is a done deal. You don't have like a 30-day return policy on a house. Hopefully they learned about all these problems in due diligence. So the question comes up. We go to the final walkthrough as close to settlement as we can. I always did mine on the way to the attorney's office. We're doing the final walkthrough. We see this home vacant for the very first time. And I learn why the seller has a picture here and a picture here. It's not because they look pretty. It's because somebody threw a fist through the wall at some point here and here. Fist is bigger than a nail hole, right? The buyer's got two choices. They either go and sign, accept the property as it is, or they don't. Once they sign, they're in. This is a tough conversation. This is a tough conversation to have with buyers, but they've got to make that decision. Now, keep in mind, we're on our way to the attorney's office anyway. So these other provisions made in writing, maybe buyer and seller can agree, all right, we'll go ahead and close, but the seller will want over here real quick, or they'll call their guy to come over and fix these holes, repair these holes. But it's important that we hear. We've got to hash all this out before they sign. Don't tell them to sign and then we'll figure it out. Once we sign, we've accepted the property in its then existing condition. Is everybody hearing me? I can't make this decision for the buyer. This could be another place where delays come up. So the final walkthrough, even if your buyer doesn't want to do the final walkthrough, you need to go and I need you to document it. I need you to video going through the home and looking at everything. If your buyer doesn't want to go, I mean, they need to be there. But I can't make anybody do anything. I can't like hog time and put them in the trunk and drive them to the final walkthrough. So they got two choices. They either go and sign and accept, or they don't until we get this worked out. Very tough conversation to have, you guys. But don't look at your buyers. Oh, sign and then we'll figure it out. What does the contract say? Comments on that? Five is buyer representations. Buyer representations is information that the buyer is relaying to the seller. The seller should be able to rely on this for accuracy when they're deciding whether or not to enter into a contract with this buyer. So some things that the buyer has to represent to the seller. First off, how are you going to get the funds to complete the purchase? That's pretty much what the seller cares about, right? Do they have the money? Can they get the money? So the buyer has to represent those funds to complete. And we got two choices. This is either a cash buyer or the buyer's getting a loan. If it's a cash buyer, they intend to pay cash in order to purchase this property. They do not intend to obtain a loan or find sources other than from the buyer's own assets. Verification of cash available for settlement is or is not attached. The blue note says if a buyer does not intend to obtain a new loan and or funds from sources other than buyer's own assets, seller is advised prior to signing this offer to obtain documentation from buyer which demonstrates that the buyer will be able to close without getting a loan. This is when your buyer, your cash buyers, should get us a proof of funds letter from their bank. I don't need a copy of their check, of their bank account, of their monthly statement, but the bank can drop a letter and say, as of this date, the buyer has X amount. I don't even need the full amount in your account. I just need enough to cover the purchase of the property. But that's a proof of funds letter from their bank saying that they have the funds. Or your buyer's going to get a loan. Buyer intends to obtain a loan, other funds to purchase the property from the following sources. So they could get a first mortgage, a second mortgage, or other. First and second mortgage or first mortgage, what's the loan type? Best practice is to include their pre-approval or pre-qualification letter It's not required. There's no license law or commission rule that says that they have to. But you know what a seller wants to see? Seller's not going to take your offer seriously if you don't have your buyer's pre-qualification or pre-approval. So absolutely a best practice to include that information. They might be getting a second mortgage. So identifying that here, and then other funds. There are so many first-time home buyer programs out there, for example, down payment assistant programs. So any of that would fall under other funds. The blue note says buyer's obligation under this contract are not conditioned upon obtaining any loan or other funds from sources other than the buyer's assets. Some mortgage loan programs and other programs providing funds for the purchase selected by the buyer may impose repair obligations and or additional conditions or costs upon the seller or buyer. More information may be needed. Material changes with respect to the final purchase price that affect the term of this contract are material facts that must be disclosed. We've mentioned, like for example, the VA loan. The VA is going to require the buyer to get the pest inspection. But here's the kicker. They usually don't let the buyer pay for it. So if the buyer's not paying for the pest inspection, who's up? Seller. Only two parties. Buyer's not paying for it, seller's up. Listing agents, is that important when you present an offer? That the seller may be on the hook for the pest inspection? I got a form for that. We got an FHA VA financing addendum. Fun with forms tomorrow. I'm trying really hard to prepare you guys for tomorrow night. Today is just fun with form. Tomorrow is fun with forms. It'll be a good time, I promise. Any questions on buyer obtaining the loan, representing to the seller how they're going to purchase the property, cash, loan, etc. Let's take 10. How we doing? Doing good? What do we think? Is this good stuff? There's a lot of good stuff in the contract, isn't there? Do we see the benefit of knowing what's in the contract? Protect your buyers and sellers? It's huge. Have I mentioned they're not reading this contract? Buyers and sellers aren't reading this 17-page offer to purchase and contract because they think we are. They expect that we know. All right, so where are we? We're number 5, buyer representations. We talked about buyer, representing how they're gonna pay for the property. Another thing that the buyer has to represent is whether or not they have other property to sell or lease. So the previous paragraph, we said, hey, buyer, if you have to sell or lease property, do it during due diligence. Now under buyer representations, the buyer is letting the seller know that they do or do not have another property to sell or lease. So check a box. Buyer does or does not have to sell or lease other property in order to qualify for a new loan or to complete the purchase. Then we're told, complete the following only if the buyer does have to sell or lease. So if you check does not, you're all set here, move on. If you check does, we're going to put the other property address. What property is your buyer selling? If applicable, buyer's other property is under contract as of the date of this offer. A copy of the contract has either been previously provided to the seller or accompanies this offer. We're told that the buyer can mark out any confidential information, such as the purchase price, the buyer's identity, prior to providing a copy of the contract to the seller. The seller may just want to see that there's a bona fide legitimate contract in place, but we need to make sure that we're sharpieing out, marking out that confidential information. Failure to provide a copy of this contract shall not prevent this offer from becoming a binding contract. However, all caps, seller is strongly encouraged to obtain and review the contract on the buyer's property before accepting this offer. Then we're told to check if applicable. Buyer's other property is not under contract as of the date. Buyer's property, we're told to only check one, is listed with and actively marketed by a broker, will be listed or actively marketed by a broker, or buyers attempting to go for sale by owner or for rent by owner. Property under contract generally looks better to a seller versus one that isn't even listed yet. So make sure you're not putting your cart in front of your horse. If that buyer wants to buy and they got another property to sell, I mean, you can present an offer, but best practice, if we have that contract, at least the seller knows that the buyer's made it that far in the process, as opposed to hasn't even marketed yet. But it's all part of the negotiations. The seller can either accept it, reject it, or counter. Blue Note reminds us that this contract is not conditioned upon the sale or lease or closing of buyer's other property. If the parties agree to make this contract conditioned on the sale or lease, an appropriate contingency addendum should be drafted by a North Carolina real estate attorney and added to this contract. Again, our contingent sale addendum has retired. It's out there in the universe. So if you come across it, it's retired. We got to have an attorney draft up that contingency.
If I'm selling my house in another state and it's not a North Carolina real estate attorney that added or that drafted up the addendum, contingency addendum, is that a problem with the contract or is it negotiable?
You know me, what's the contract say? So it tells us that this contingency should be drafted by a North Carolina real estate attorney. Now, you can have a contract with another state that you can share with the seller, right? Because it is a contract still. But I'm a fan of it's
Okay.
written there for a reason, you know. I don't know the reason, but but it's there specific, that North Carolina real estate attorney.
Gotcha.
Because other states do things differently, you know. That's a good question. Performance of buyer's financial obligation. To the best of the buyer's knowledge, there are no other circumstances or conditions existing as of the date of this offer that would prohibit the buyer from performing their financial obligation. So we have either a proof of funds if they're going cash, or we have a pre-approval or pre-qualification. You know, if the buyer knows that they are facing bankruptcy, that would be something that could affect their financial obligations, and something that the buyer should consider representing to the seller, for example. Buyer has to represent to the seller whether they have or have not received the seller disclosures. So we got two seller disclosure. We got the RPODs, or the Residential Property and Owners Association disclosure statement. Are you guys okay if I say RPODs? That's a mouthful, and I will trip over it every single time. So when I say RPODs, that's what I'm referring to. Buyer has to acknowledge that they have or have not received the RPODs. Buyer has received a signed copy of the RPODs prior to making this offer and acknowledges compliance with this North Carolina general statute. Again, you don't need to know it, but it's there for reference. So if questions comes up about the RPODs or the Residential Property Disclosure Act, there's your source right there, this law. So buyer has received the RPODs, or a buyer has not received a signed copy of the RPODs prior to making this offer, and shall have the right to terminate or withdraw this contract without penalty, and that does include a refund of the due diligence fee prior to whichever the following events occur first. So they've not received the RPODs, we still make the offer. I'm not going to hold off on the offer because we don't have the RPODs. I'm not going to slow things down because I don't have the RPODs. But the buyer has the right to terminate whichever the following events occur first: the end of the third calendar day of receipt, or the end of the third calendar day following the effective date. The majority of the time, buyer's agents, we can find the RPODs as an attachment in MLS. That's something that the public doesn't see. If you haven't gotten into MLS yet, that's something you'll have to look forward to, or things like attachments. And you'll most of the time see the RPODs in the attachments. But in the event that you haven't seen it, you weren't able to provide it to your buyer. I mean, it's not an MLS. When it comes to the RPODs, my duty is to get it in the buyer's hand. So if it's not an MLS, I'm going to call the listing agent. I'm going to try to get that before I present the offer so they can have that information. However, again, I'm not going to hold off on presenting the offer for the RPODs. So go ahead and present the offer, check the box acknowledging that the buyer has not received a copy, and let your buyers and sellers know that this could give the buyer a free out. They'll get their earnest money back. And this says, this is one of those rare occasions that they will also get their due diligence back. Keep in mind, this is because the buyer fails to receive it. It's not because they don't like how the seller completed it. Remember, caveat emptor, the seller has every right to say no representation. So it is just failure to see it, failure to review it. The RPODs may also be exempt from this transaction. Times that the RPOs are exempt. When we look at the guidelines for 2T, they give us a list of reasons why the RPOs might be exempt. So if you think your RPOs is exempt, run straight to the guidelines and see if your reason falls under that category. The number one reason why the RPOs might be exempt is new construction. Or if I may word that a little differently, never before lived in dwelling. People can't talk about the condition of the property if nobody has ever lived there. So the RPOs would be exempt. And then we go through that exact same exercise, only with the MOG, the mineral and oil and gas rights disclosure, another seller disclosure that they're required under that North Carolina general statute to provide. The either buyer has received a copy of the MOG or they have not, in which case the buyer shall have the right to terminate without penalty, including a refund of the due diligence fee, prior to whichever the following events occur first. End of the third calendar day, after receipt, end of the third calendar day, following the effective date. Both of these also have secret option number 3, if possession has already happened. So think about like a, dang it, I just lost it. At least the tenant's already living there. They know better about the property than the seller does, right? Because they're already living there. So that would be a settlement or occupancy by the buyer in the case of sale or exchange. So the buyer's representing to the seller, they have or have not received seller disclosures. Again, they're seller disclosures, which means the seller is responsible for completing them. My responsibility with the seller disclosures is to play delivery man and get it from the seller to the buyer. The vehicle of delivery does not matter, but we have a duty to get that from the seller to the buyer.
Which disclosure statement are they referring to? When it says, whichever of the following events occur first.
So this one is referring to the Residential Property Owners Association disclosure statement. And this one's referring to the MOG.
Okay.
So when they say, I'm trying to see here. The end of the third day following the disclosure statement, it's this one or this one, whichever one we're under. Is that what you were looking at, Rebecca? Is that disclosure statement?
Yeah.
Yeah.
Mm-hmm.
Yeah, it's whichever one we're under here.
Okay.
One more thing. Buyer's receipt of the MOG does not modify or limit the obligations of the seller under paragraph 8G below, and shall not constitute the assumption or approval by buyer for any severance of mineral, oil, or gas rights, except as may be assumed or specifically approved by the buyer in writing. This note's letting us know that if the seller has severed the subsurface rights, or if the seller intends to sever the subsurface rights, we need to get an attorney involved, because severance of subsurface rights got out of our league really fast. That's definitely a legality thing. So if the seller discloses on the MOG that they have severed or they intend to sever, then the parties are advised to consult with an attorney to make sure that those rights convey properly. Any questions on buyer representations? Number 6 is buyer's obligations. What are they responsible for? What are their obligations? Well, here's special assessments again. So buyer's obligations, what are their responsibility for special assessments? Buyer shall take title subject to all special assessments that may be approved following settlement. So if the seller knows of any proposed special assessments, anything that's on the table for discussion, they should let the buyer know that. But the buyer's not responsible for special assessments, only those that are approved following settlement. Spoiler alert, when we get to the seller obligations, we're going to learn that the seller's responsible for special assessments that are approved before settlement. Good rule of thumb, whomever owns it when it's approved is responsible for it. Buyer's obligations also fall under responsibility for certain costs. The buyer shall be responsible for all costs with respect to, and again, this takes us back to our who pays for what. So the buyer is responsible for obtaining their loan, any loan fees, discount points, loan origination fees, interim interest, anything that the lender is charging the buyer is responsible for. Charges by an owner's association or a management company. We're going to see that again in just a second. Buyer pays for the appraisal, the title of search, the attorney's fee, title insurance, any fees charged by the closing attorney to prepare the buyer's documents, buyer's responsibility for recording the deed, and buyer's responsible for preparation and recording of all instruments required to secure the purchase price. So the lender's deed of trust, for example. So how do we know who pays for what? A lot of that is spelled out in the contract. And then authorization to disclose information. Various parties need a copy of the contract for them to do their job. The lender needs the contract, the attorney needs the contract, you and I need a copy of the contract. So this is just the buyer given permission from whomever needs it to do their job. We can send it to them. The appraiser needs a copy of the contract. So all those settlement service providers, we have that authorization to disclose. Questions on the buyer's obligations, their duties. So if 4, 5, and 6 are all about the buyer. Listing agents, 7 and 8 are all about your seller. So having the appropriate conversations with the appropriate people. First thing we're going to do, number 7, seller representations. Again, this is information that the seller is providing the buyer, that the buyer should be able to rely on for accuracy when deciding if they want to enter into a contract with this seller or not. The first thing that the seller is going to represent is how long they've owned the property. They've owned it for at least a year. They've owned it for less than a year, or they do not yet own the property. I'll talk about the do not yet to own the property in just a second. But the reason they want to know for at least a year versus less than a year. Who typically, who owns it for less than a year? Typically.
Investors?
Yeah, our investors, our flippers, our people that buy the property, flip it, and then turn around and sell it. Some lenders care about that. Some lenders have a loan product that needs to know the length of ownership for loan approval. I learned the hard way. FHA, for example. FHA requires the sellers to own the property for 90 days before they can go under contract. Why? I don't know. It's just an FHA requirement. Y'all want to know how I learned about that? I was the listing agent. Our buyers were going FHA. We submitted the contract. Y'all, my sellers, my flipper sellers had owned it for 89 days. And the lender said, underwriting, we'll kick this out because the seller has to own it for 90 days. Said, I learned something today. So we hung tight, hung out, and then tomorrow on day 90, everybody re-signed, so our dates lined up. We live and we learn, hey? But some loan products care about whether or not an investor, how long they've owned it, etc. Sellers that do not yet own the property, they might be in process of acquiring it, but it hasn't happened yet. A couple examples. Think about a builder that's buying the property, maybe buying the land, and then they're going to build on it and sell it as a package deal. They may not yet own it, but they might be in process of purchasing it. Another example, recent, new to real estate, you guys might have heard of wholesalers. There's not one specific definition to wholesalers yet. There's not a license law or commission rule for wholesalers yet. I wouldn't be surprised if that's coming soon to this state. But wholesalers, think about Costco. Wholesalers buy in bulk and then turn around and sell at a discount. And it might be that the wholesaler is in process of buying it, but they don't yet own it. The buyer's got to represent their ownership, how long they've owned it. Primarily, there's a couple other reasons, but primarily because that's what the lender cares about. The seller's got to represent that the property is residential and built prior to, there's our magic year of 1978. The good news, you guys, once you're done with post, you no longer need to know that date. That date is in the contract for you and you don't have to worry about it. With that being said, I also know that that date will be forever ingrained in your brain. 90 years from now, not 90 years, but maybe 40 years from now, we're going to be in a nursing home somewhere going 1978, lead-based paint, right? So we got the date, but the contract helps you out. Anything built prior to 1978, and then the contract tells me that I need to attach the lead-based paint or lead-based paint hazard disclosure addendum. Fun with forms tomorrow. That's another one we'll look at. Big red warning, all caps and bold. If a lead-based paint disclosure is required but not given to the buyer prior to seller's acceptance of this offer, buyer may not be obligated to purchase the property under this contract under federal law. Lead-based paint is federal. It overrides state. Seller's responsible from an owner's association dues. Seller authorizes and directs any owner's association, any management company of the owner's association, any insurance company, and any attorney who has previously represented the seller to release to the buyer, their agents or representatives, true and accurate copies of the following items affecting the property, including any amendments. And then we have a list of documents that we may have, the seller may have from the owners association. So if they have the bylaws, if they have the articles of incorporation, there's your restrictive covenants. Any of these documents, the seller is going to provide those to the buyers. May have to be at the buyer's request, but the seller has a duty to provide true and accurate copies of the following. By the way, this exact same list shows up on our listing agreement. So again, we can use that listing agreement as a checklist. We can tell the seller, a buyer's going to ask for this stuff. So let's go ahead and start gathering it. We know this is coming when we list it. So let's go ahead and start getting it together. I'm telling you guys, use the listing agreement as a checklist. If you see it that way, it's a game changer. But it's one way to avoid all those things we have to talk about with sellers. The listing agreement is a great place to start. Still under owners association, the seller is also going to represent who the owners association is. Assessment dues are X amount per what? Per month, per year, per quarter. We got the name and address, contact information of the association. And we actually have a place for 2 associations because some place has 2. Some place you have to join, Larissa's got 2. Some places you have to join like the entire HOA, and then you might have a separate HOA for your section. So there's 2 HOAs. Some places might have a mandatory HOA for the common areas, and then an optional HOA for the pool. I'm not telling you what you're going to sign up for. We just have the seller representing. Larissa, can we ask what yours? You don't have to share if you don't want to, but you put your hand up. So what are yours?
What are my what?
Your HOAs. You had 2?
You want to know my dues?
No, what each one covers. Why do you have 2? They
Right,
do 2
so-
different things, right?
Yeah, so we have like an umbrella that encompasses the whole area. And like you said, we have different sections of that area. So, and there are different types of housing in each area. But it's called Bermuda Bay is the umbrella, and they pay for, like you said, the roads, the pool, the common areas. But then each section pays for, or they also have insurance. But then each section pays for our part of the insurance, landscaping, lighting. And so, yeah, so we have 2. And they're
2
both
different dues.
expensive.
2 different dues, 2 different things, 2 different things going on.
2 different boards, 2,
2 different board. Yep. 2
all
different
different-
meetings.
Yeah,
And to that point, if you have different sections, I mean, some communities, I had a friend that recently bought a townhome up in Jefferson, North Carolina, Jefferson Landing, if you're familiar with that. And that's how they work too. There's the HOA for Jefferson Landing. Once you get in Jefferson Landing, there's, multi-million-dollar homes, there's townhouses. So each section is different. They have their own HOA. However, the big picture drawed it up. All we're doing right now is representing to the buyer. We may have 1 HOA, we may have 2. Letting them know that information. Thank you for sharing. Another thing that the seller has to represent is fuel tanks and fuel. Y'all, I don't know much that has had buyer and sellers in court over the years other than fuel tanks and fuel. This paragraph has recently been revamped. It used to be they talked about fuel tanks in multiple places in the contract. And a couple years ago, they said, let's just put it all together. So we only have to talk about fuel tanks once and we can address everything. Thank you, Forms Committee, for making that a little easier for us. There's a lot going on with fuel tanks. So first off, to the best of the seller's knowledge, we're still under seller representations. To the best of the seller's knowledge, there is or is not a fuel tank located on the property. If yes, complete the following. And then we have to describe the tank. You can see here we have a place to describe 2 tanks. So what's the use of the tank? It is in use or it is not in use. Is it owned or leased? Is it above ground or below ground? What's in it? The type of fuel. And then the contact information of the fuel vendor who comes out and fills it up when it's empty. So we have the opportunity to address 2 tanks. Tanks included in the sale. Buyer and seller agree that any tank described above that is owned by the seller shall be included in the sale as part of the purchase price, free of liens, unless we exclude it in paragraph 2E above. And if we were to go back up, we would be reminded that 2E above is our fixture exclusions. So if any tanks are going to be excluded, we're advised to go back up to 2E, fixture exclusions. The fuel, this is what's caused the disputes over the years. The seller may use the fuel in the tank described above through settlement, but may not otherwise remove the fuel or resell it. Any fuel remaining in the tank as a settlement shall be included in the sale as part of the purchase price, free of liens. So many times on settlement day, sellers are trying to figure out how to take their fuel. At least they used to be, until they helped us out with the contract so we can have these conversations. So the seller can use the fuel in the tank, but when the property conveys, the fuel conveys with it. So this is what's happened. Your seller has their fuel tank filled. I don't know, $500, $800, I don't know. I've never had a fuel tank filled, but it's X amount of dollars. So we got a full tank, and then they decide to sell. And the seller says, I just filled the tank. Am I not going to get my money back? Are you telling me I just spent all that money on fuel and I'm not going to get the fuel and I'm not going to get my money back? Smile sweetly. If push comes to shove, can't we always jack the purchase price up by $800 so the seller can get their money back for their fuel, the listing price, right? So it's all part of the negotiations if your CMA warrants it. But when it comes to fuel tanks, I'm going to remind you guys, what does the contract say? It's pretty clear that the seller's got to leave whatever fuel is in the tank. They can't be out there trying to siphon it out and take it with them. People are amazing, aren't they? They never cease to amaze me. Seller's use of fuel and any fuel tank is under seller's obligations, which we'll see next, to provide working existing utilities through the earlier of closing. So we got to have fuel in the tank for the home inspector to inspect the things that are powered by the fuel tank. Maybe it's the water heater, whatever. Couple notes. Buyers shall be entitled to conduct inspections to confirm the existence, type, and ownership of any fuel tank located on the property. Buyers advised to consult with the owner of any leased fuel tank regarding the terms under which the buyer may lease the tank and obtain the fuel. So a lot of those leases can be transferred to the new owner, so they have that fuel. Next blue note. State law provides that it is, here we go, unlawful for any person other than the supplier or the owner of the fuel supply tank to disconnect, interrupt, or fill the supply tank with liquefied petroleum gas without the consent of the supplier. Fuel. Again, guess what shows up in your listing agreement? Fuel tanks. So we can have these conversations, let the sellers know what the buyers will expect, because that's what the contract says. The last thing under seller representation is whether or not the property is subject to any leases. If the property is subject to a lease, buyer and seller shall include either the rental income investment property provisions of the additional provisions addendum that we'll see, or the Vacation Rental Act, which we will mention. So we will talk about both of these forms tomorrow. That additional provisions addendum is probably the one that pops up the most in our contract, because it's probably the one that we see, the addenda that we see the most. So we'll make sure we definitely go over that one. So the seller's just representing if the property is or is not subject to any leases. More on that in our additional provisions addendum. Questions on any of the seller representations? Number 8 is the seller obligations. What are their obligations? They have to prove evidence of title, payoff statements, and non-foreign status. So seller agrees to use best efforts to provide to the closing attorney, as soon as reasonably possible after the effective date, copies of all title information in possession of or available to the seller, including but not limited to. And then there's a laundry list of documents that the attorney may request from the seller while the attorney is doing that title search. Remember, the buyer hires the attorney. So the attorney's number one interest is to make sure that their buyer client gets that clear marketable title. And while they're doing that title search, if the attorney needs any documents for the seller to clear up any title issues, the seller's agreeing right here to assist the attorney in whatever way that they need to make sure that that buyer's getting clear marketable title. Seller's also going to provide to the closing attorney all information needed to obtain a written payoff statement from their lender regarding any security interest in the property as soon as possible after the effective date. And seller designates the closing attorney as the seller's agent with express authority to request and obtain on seller's behalf payoff statements and or short pay statements from any such lenders. At some point, the attorney has to get the seller's payoff for any of their existing mortgages, and that payoff has to calculate principal and interest to the day of settlement. So it's going to be to the penny, what does the seller owe as of today? If closing gets delayed, then that will need to be recalculated, because we have to take into account additional interest and additional principal. So the attorney has permission to communicate with the seller's lender to get that payoff statement. As soon as reasonably possible after the effective date, seller shall provide to the closing attorney all information needed to obtain a written statement of seller's account from any owners association or HOA. Seller designates the closing attorney as the seller's agent with express authority to request and obtain on seller's behalf a written statement of their account of the property. Upon request from the closing attorney, seller shall immediately pay any fees or charges by the owners association for such written statement. So the HOA may set a charge, in which case the seller, again, is agreeing to work with the attorney to do what we need to do for the attorney to get that documentation from the HOA so we can transfer it from the old owner to the new owner. We got to set up the new owner in the HOA. We got to make sure the seller is up to date and current on their HOA. If the seller is not a foreign person as defined by the Foreign Investment and Real Property Tax Act, Seller shall also provide to the closing attorney a non-forest status certificate pursuant to the act. In the event the seller does not provide a non-foreign status certificate, seller acknowledges that there may be withholdings as provided by the Internal Revenue Code. So this is an IRS thing having to do with taxes and whether or not the seller falls under that category of in foreign investment, foreign person. Best way to do that is to Google Foreign Investment and Real Property Tax Act and see who may fall under that. By the way, this also shows up in the listing agreement. So we can have these conversations. We can ask, find out from the seller if they fall under this. And it's just an IRS thing, how their taxes are paid, whether they're considered foreign or non-foreign. The sale of the property, the attorney will report the sale of the property to the IRS on behalf of the seller. I don't know what their taxes are going to look like this year, but I know the sale has to be reported. Have your seller talk to their accountant. And the sellers are responsible for it, but the attorneys go ahead and submit that form just in case they forget. So the attorneys handle that on their behalf. So the sellers can't avoid reporting that to the IRS. Most attorneys handle that on their behalf. Authorization to disclose, we saw this in the buyer's obligation. So again, people need copies of contracts, various documents. I'm seeing title insurance at a glance. So again, this is just the seller giving authorization to anybody that needs copies of the contracts or documents, whatever they need to do to make this transaction happen. We have permission to do so. Access to the property. Seller has an obligation. Seller shall provide reasonable access to the property through the earlier of closing or possession by buyer, including but not limited to allowing the buyer and their agents and representatives an opportunity to conduct due diligence. The seller can't deny the buyers, investigators, and inspectors on the property. They cannot not allow those people on the property to do due diligence. The seller has to provide reasonable access for the buyer to verify the completion of negotiated repairs. And then the seller needs to provide access to the property for the buyer to conduct the final walkthrough. So we're under contract. The seller's got to let people in their home. And guys, let's be reasonable. There's a difference in the whole house is sick. Today we have the flu. Can we reschedule? Well, of course we can. Nobody wants to come into a flu house anyway, There's a difference in everybody being sick versus the seller never letting anybody in. The buyer can't do their due diligence if the seller doesn't let them on their property. The rest of this then, seller's obligation includes providing, here's those existing utilities operating at seller's cost. So they can't cut the power and the water. They can't cut the utilities. And that does include any connections and dewinterizing. This blue note is reminding us of the warning above in paragraph 4 that the buyer's limitations on the right to terminate this contract as a result of buyer's continued investigation following the expiration of the due diligence period. Removal of the seller's property. Seller shall remove by the date possession is made available to buyer all personal property that is not part of the purchase price and all garbage and debris from the property. The contract used to say, and I wish it still did, the contract used to say that the property needs to be broom clean It doesn't say that anymore. Now it just says that the seller's got to get their stuff out. They got to get their garbage and trash out. They can't leave a heap. But remember, we go to the final walkthrough and there's a bunch of junk and a bunch of stuff. The buyer's got two choices. They either go and sign and accept the property in its then existing condition, or they don't. We work it out with the seller. When y'all gonna come clean this house? I'm not signing until we work this out, until we make these arrangements. Sellers sometimes think they're leaving the buyers gifts. And really what that gift is something that the seller decides they don't want to move after all. The grill, for example. I don't want to move the grill, so I'll just leave it for the buyer. Guess what, y'all? If the buyer wanted your grill, they would have asked for it in personal property. And there's a really good chance the buyer didn't want your grill because theirs might be better. To the buyer, your grill is trash unless they want it. Everybody with me? We're not leaving gifts. We're not leaving presents. Affidavit and indemnification agreement. Again, the indemnification part is the seller saying they are going to indemnify the buyer, hold them harmless against things that are not covered in this contract. Seller shall furnish at settlement an affidavit, an indemnification agreement, and form satisfactory to buyer's title insurance company, executed by the seller and any person or entity who has performed or furnished labor, services, materials to the property within 120 days prior to settlement. If I'm talking about 120 days, what do you guys think of? What do we think of 120 days? Who do we think of? I'm seeing mouths move. Y'all remember that mechanics lien? Mechanics, anybody that provides services, labor, etc. The mechanics have 120 days after the work is complete to file the lien for anything that's not paid. So let's run a scenario. Buyer and seller goes under contract. Buyer asks the seller to do repairs. Seller says, sure, I'll be happy to do the repairs. But guess what? The seller never pays the mechanic. We go to closing, the deed changes hands. On day 119, the mechanic files the lien. It's a specific lien, which means it attaches to the property. So the seller signs an affidavit at settlement saying this can't happen. They sign an affidavit saying, look, all these people have been paid. I promise they can't come back and file a lien. Do people lie sometimes? Yeah, I'll sign this. Lies, lies, lies. Because the seller is signing this affidavit saying this can't happen, and now it does, that mechanics filed a lien, that's what gives title insurance the right to go after the seller. Remember, title insurance covers the current owner from errors of the past. That mechanics lien wasn't even filed when the attorney was doing the title search. So there's no way the attorney could have found it. Seller signed something saying this wasn't going to happen. And this is what gives the title insurance permission, we'll say, to go after that mechanic. Buyer's agents, we can take an extra step to help prevent this as well. So when you're submitting your repair request, I would recommend putting verbiage in there, something along the lines of seller to provide paid in full invoices. So that shows us that these mechanics for agreed upon repairs has been paid. This also shows the buyer who did the work. So if it breaks a week after settlement, they know who to call. So buyer's agents, we can add that verbiage, paid in full invoices upon the completion of the agreed upon repairs. Designation of a lien agent, payment and satisfaction of liens. If required by this North Carolina general statute, seller shall have a designated lien agent. Seller shall deliver to buyer as soon as reasonably possible a copy of the appointed lien agent. All deeds of trust, deferred ad valorem taxes, liens, and other charges against the property not assumed by the buyer must be paid and satisfied by the seller prior to settlement. So this tells us that deferred taxes, liens, and other charges against the property are on the seller, debit to the seller prior to settlement. Seller shall remain obligated to obtain any such cancellations following closing. So if we don't have this information by closing, the seller still has an obligation to get it. Probably one of the seller's biggest responsibilities is to provide good title and legal access to the property. This is that clear marketable title. Seller shall execute and deliver a general warranty deed for the property in recordable form no later than settlement, which shall convey fee simple marketable and insurable title without exception for mechanics liens, lis pendens, monetary liens and judgments, and free of other encumbrances or defects that would materially affect the value of the property, including those that could be revealed by a current or accurate survey, except for this year's taxes, easements and unviolated covenant CCRs, such other liens, encumbrances, or defect that may be specifically approved by the buyer in writing. The property has to have a legal access to a public right of way. This is where the attorney's going to get with the seller to make sure that the seller is doing what they're responsible for. And their responsibility is to provide that clear marketable title, to deliver the general warranty deed. Couple blue notes. Buyer's failure to conduct a survey or examine title of the property prior to the expiration of the due diligence period does not relieve the seller of their obligation to deliver good title. So if the buyer waives the survey, the seller's still on the hook to provide that good title. Next blue note, if the sale of the property is a short sale, consideration should be given to attaching the short sale addendum. As an addendum to this contract, another one, fun with forms, tomorrow night. Still on seller representations. I'm sorry, seller obligations. We're on seller seller obligations. So the seller's got quite a bit. They got a little laundry list to do. I think they have more to do than what we kind of realize. I mean, big picture, they got to provide clear marketable title, but they got other things on their to-do list. There's still a little bit more to say about seller obligations. But right now, let's take a break. When we come back, we're going to wrap this thing up and the night up. We doing our jumping jacks and energy drinks and whatever we do to get through the last hour. Remember, you guys, if you need to get up, move around. In a night class, I'm much more lenient because hey, I get it. Y'all see how much I sit. I'd be out cold if I did. So, you know. Still under seller representations, lots more for the seller to represent. Government compliance. It is a condition of this contract that the property be conveyed free of any material violations of law, ordinance, permit, or government regulations, including those relating to building, stormwater, impervious surface, environmental protection, and zoning, unless the seller has specifically disclosed such violations prior to the effective date. If the buyer establishes that a violation exists after the effective date prior to closing, then buyer must promptly notify seller and seller may cure the violation. Unless otherwise agreed, if seller does not cure the violation prior to closing, then buyer may choose to accept the violation and proceed to settlement, or terminate this contract and receive a refund. Here's another opportunity where they not only get their earnest money back, but also their due diligence fee. Other than seller breaches, there are a couple places that we could get the buyer down. So let's break this down. What the heck are we talking about? If there's any kind of issue with, like it says, building, stormwater, environmental protection, zoning, listing agents, this is in your listing agreement now. It is recommended, even though the seller doesn't have to disclose, if the seller knows of any of these governmental compliance issues, it is recommended that the seller does disclose. They don't have to, but we're going to suggest that they do. Because here's the deal. If they do not disclose and the buyer finds them, so buyer establishes that violation during their due diligence inspection, investigation, buyer finds them, they notify the seller and give the seller the option to cure the violation. If the seller does not, that's what may give the buyer the right to terminate this contract. If the seller discloses the violation, then the buyer doesn't have that right to terminate. So if they know of anything in this case, it might be in their best interest to disclose. And then the rest of this paragraph doesn't exist. If they don't disclose and the buyer finds it, they go to the seller. I found this governmental compliance violation, fix it. If the seller says no, that buyer could terminate, get their earnest money and their due diligence fee back. Again, this shows up in the listing agreement so we can have these conversations, part of our checklist, and encourage them to disclose. We don't want to lose a buyer. We don't want the buyer to terminate. We certainly don't want the buyer coming after the seller for the earnest money and the due diligence fee. So with this, and this is fairly new. I think this was just added to the contract like last year. So it's still a fairly new provision. And to the listing agreement. Deed, taxes, and fees. Seller shall pay for preparation of the deed. Who pays for what at closing? Seller pays for preparation of the deed and all other documents necessary to perform seller's obligations under this contract. Seller's going to pay for state and county excise taxes and any deferred, discontinued, or rollback taxes, local conveyance fees required by law. This deed is to be made to the buyer, a corporation, LLC, or other business entity, a trust for which the buyer is the beneficiary, or any relative of buyer, and or other. If it's other, then we are instructed to insert the names. Who is other? So we need to know who the deed needs to be made out to. If it's the buyer listed on page 1, the attorney's got that. They should verify that name, verify that identity anyway. They used to have us write in the buyer's names regardless. Who's the deed going to be made out to? And attorneys across the state complained about us. Evidently, we were no good about putting a buyer's name in that blank. Across the state, we failed. So attorneys, y'all, enough attorneys complained about us that NC Realtors updated their form and said, look, if it's the buyer, just make it out to the buyer. If it's the corporation or LLC, that's going to be the buyer on page 1. So the only time they're going to let us write something in is if it's other. We've lost that privilege. I don't know what we did, but we have lost that privilege. We can no longer write in the buyer's names. Comments on that? Agreement to pay buyer expenses. Seller shall pay at settlement X amount toward any of buyer's expenses associated with the purchase of the property at the discretion of the buyer and or lender, if any, including FHA, VA lender and inspection costs that the buyer is not permitted to pay. What the seller, if any, that the seller pays as part of the buyer's closing costs, again, that's a negotiable. And remember, you guys, 0 is a negotiated amount. Also remember, we're not going to leave a blank. And this is one field that I definitely need you guys. If we're not going to agree, if the seller's not going to do any seller pay closing costs, please make sure you identify that amount. Don't leave a blank. Also, please note, and this just came up in my office the other day. Remember, blanks are asking for something very specific. This blank is asking for a dollar amount. I had a team member that got an offer and it was allowable closing costs not to exceed 4.5% of the loan amount. Is that a dollar amount? Is that what that blank is asking for? The blank is there for a reason. If they wanted a free for all for us to write anything in, they would have allowed us to fill in the blank, but specifically they want an amount. So it's a negotiated amount. And remember, 0 is a negotiated amount. Keeping in mind, if this is any FHA or VA buyers, there may be certain inspection costs that the buyer's not permitted to pay. So in that case, those amounts need to be part of any seller pay closing costs. The blue note says the parties should review the FHA financing addendum, which we're going to do tomorrow. Prior to entering an amount into this paragraph, there are certain lender costs that cannot be paid by the buyer at settlement, and the amount should be included in the blank above. You'll know if your buyer's going FHA or VA, be in contact with that lender to find out specifically what this buyer for this property is not permitted to pay, so we can make sure that we cover that amount in agreement to pay buyer expenses. Seller responsibility, owner's association fees and charges. Seller's going to pay any charges by an owner's association or management company for the association under paragraph 9A of this contract that we're getting to. And then payment of special assessments. So we said buyer's responsible for any special assessments that are confirmed after settlement. Seller is responsible paid in full for all special assessments that are approved prior to settlement. So whenever we vote aye, whomever's the owner is responsible for it. Seller pays for those that are approved prior to settlement. Buyer pays for any of those special assessments that are approved after settlement. Seller's responsibility is to pay those in full, whether they're payable in a lump sum or future installments. The HOA is just going to want to go ahead and collect from the seller now as part of their proceeds, so they don't have to go after the seller. Some HOAs will let you pay. If we're going to redo the roof, maybe they'll put it down in installments where you owe X amount a quarter for the next so many quarters. That's helpful. I own a little condo in High Point, and they've let us do that. They've repaved the parking. I mean, y'all, this condo is like, the complex was like mid-70s when it was built. So we've recently just redone it all. Vinyl siding, new roofs, parking lot. They put a fence, a bigger fence up around the pool. So thankful for installments. That would hurt otherwise. Either way, the seller's responsible for anything approved prior to settlement. Late listing penalties. This is addressing any delinquent property taxes. So if the seller never paid last year's taxes or the year before that or the year before that, the contract tells us that the seller is going to pay those part of their proceeds of settlement. Negotiated repairs or improvements shall be made in good and workmanlike manner, and buyers shall have the right to verify same prior to settlement. I know we sometimes get a little giggle over this good and workmanlike manner. Not all sellers are handymen. Not all homeowners are handymen. I mean, let's face it, we can all get a hammer. We all have access to YouTube, right? Do we know what we're doing? Not always, not necessarily. Good and workmanlike manner is meant to mean per general contractor standards, somebody that knows what they're doing. Buyer's agents, something else to consider when you're asking for repairs is to request if there's somebody in particular you want to do the repairs. So putting verbiage in there like to be completed by a licensed electrician or a general contractor. That prevents the seller from saying, I can fix it. Especially if we don't know. Y'all are out there showing property. Have y'all seen the handyman special yet? You'll know it when you see it, and you will definitely not want that homeowner working on those repairs. Home warranty. Select one of the following. Either no home warranties to be provided by the seller. The buyer may obtain a 1-year home warranty at a cost not to exceed X amount, another dollar sign there, which includes sales tax, and seller agrees to pay for it at settlement, or seller has already obtained the 1-year home warranty at a cost of X amount. Yeah. Some home warranty companies, if the seller agrees to buy the buyer's home warranty, that home warranty company may cover the seller while they're listed. So it's more than just covering the buyer, because Murphy's Law says as soon as you put your home on the market, something's going to break, right? So some sellers like that idea of that coverage of the home warranty. Again, the home warranty is always going to be a negotiable amount. And we hash that out here. Our blue notes telling us that home warranties typically have limitations on coverage. Refer those specific questions to the home warranty company. There's a representative that you can get in touch with that can help you address that. And then the last thing under sellers obligations. Are we sellers obligation? We're in sellers obligations still. The last thing under seller's obligation is in the event of seller's breach. I got a whole paragraph for breach. So we'll see that in paragraph 23. Did that work, Addie? I think we're having computer issues. She's freezing up on us. There she is. Charges by an owners association, responsibility for payment of charges by an owners association or management company of the association shall be allocated between buyer and seller as follows. So again, who pays for what when it comes to charges by the owners association? I mean, boom, there it is. It spells it out for us. Fees that the seller's responsible for paying. I'll let you guys look at that. Fees for the buyers that are responsible for paying. I think Zoom, not just Zoom, but the internet gets bogged down in the evenings because we're all home playing around, kids are gaming, right? So I just think evenings tend to be a little bit. So Addie, if you need to come in on your phone, I don't know if that would make a difference or not. Maybe try that. If that would help, you're welcome to try that. So just various fees. There's going to be transfer fees, like the HOA admin has to process the owners, right? We're going to change up owners. So from the seller to the buyer, there's administrative fees, transfer fees, etc. So again, this just spells out who's responsible for what. The contract talks about prorations and adjustments. Unless otherwise agreed, the following items shall be prorated, with the seller responsible for the prorated amounts through the day of settlement. Seller entitled to the amount of the prorated rents through the date of settlement, and either adjusted between the parties or paid at settlement. And then it gives, us a list of things that the parties may prorate. So this year's real property taxes. If there is any personal property that we're doing an outside bill of sale on, so the car, for example, the boat, the RV, we're going to prorate this year's personal property taxes, prorate rent, if any, and HOA dues, if any, with the seller being responsible. Condition of property, risk of loss. Two things going on in this provision. Condition of property at settlement. If the property is not in substantially the same or better condition at closing as on the date of this offer, reasonable wear and tear expected, buyer may terminate this contract by written notice delivered to seller. And here it is again. The due diligence fee and the earnest money shall be refunded to the buyer. If the property is not in such condition and buyer does not elect to terminate, buyer shall be entitled to receive, in addition to the property, the proceeds of the insurance claim filed by the seller. So we're under contract and the house burns down or the tree falls on the house. The property is damaged. The buyer's got choices. They can terminate, get their earnest money and due diligence back, or they can remain under contract, go to closing, get the property, and the seller's proceeds to rebuild. Buyer's agents, if the house is destroyed, if the house is damaged when we're under contract, your buyer's going to call you and say, oh no, what should I do? So I'd pull the contract out and read them this paragraph, let them know their options. And then they're going to say, but what should I do? And at that point, it got out of my realm. And we need to have them talk to an attorney so the attorney can go over their options. All I can tell you is what's in the contract. The attorney can get more specific. The attorney can help them decide. The attorney may recommend that the buyer talk to the seller's insurance company, right? Find out about the seller's proceeds and how and when. I mean, insurance companies aren't known for their rapid payouts. So that's something that the buyer needs to take into consideration when making this decision. The second piece of this then is risk of loss. The risk of loss or damage by fire or other casualty prior to closing shall be upon the seller. Sellers advised not to cancel existing insurance on the property until after confirming recordation of the deed. Remember, until that deed changes hands, it's still the seller's property. So the seller needs to maintain a homeowner's insurance whether they live there or not. There's kind of a misconception that the property is doubly insured on closing day, but the seller's policy is going to end when the deed records and the buyer's policy is going to begin. So I got two policies, but not two at the same time. And if the house burns down on settlement date, both buyer and seller's insurance companies are going to want to hear from the fire marshal about what time the house burned down and who was the owner when that happened, because they will be the one responsible with their insurance. Delay in settlement. We have a 7-day delay built into our contract. Delays in settlements are so common that we have a delay in settlement, specifically 7 days, built into our contract. This paragraph will apply if one party is ready, willing, and able to complete settlement, but it is not possible for the other party to complete settlement. So we're dealing with the delaying party, the one causing the delay, and the non-delaying party. The delaying party shall be entitled to a delay in settlement, give as much notice as possible to the non-delaying party and the closing attorney. If the delaying party fails to complete the transaction within 7 days, the delaying party shall be in breach, and the non-delaying party may terminate this contract, and the delaying party will suffer the remedies, the consequences of breach, as spelled out below. So let's just run an example. Let's say that the buyer, we don't quite yet have loan approval. We're close, but we don't have it yet. Maybe that 3 days prior to settlement TRID rule has caused a delay in settlement. For whatever reason, we're not ready. Buyer's loan is not ready to close on the agreed upon settlement date. That makes the buyer the delaying party and the seller the non-delaying party. As the non-delaying party, the seller has no choice but to sit still and be patient for 7 days and hope that we get loan approval. Hope that this thing closes. If the seller terminates within the 7 days, they are in breach and they will suffer those consequences of breach that we're getting ready to see. If we get to day 8 and we still haven't closed, now the seller may terminate and enforce those consequences of breach. But the non-delaying party must allow those 7 days. Delays in settlement just happen. Please tell your parties to have a plan B. Please. I don't want any buyers sleeping in the U-Haul truck tonight because they thought we were going to close and they have nowhere else to go. Please have everybody have a plan B just in case. Questions on that? Possession. When does the buyer get possession? The contract says possession, including all means of access to the property, such as keys, security codes, garage door openers, etc., shall be delivered upon closing. The buyer should not get keys at settlement. They should not be given access to the property. Every single one of us on this call has a story. We know somebody, maybe you, got your keys at settlement. As the agents in the transaction, as the brokers, what does the contract say? Not until it closes. Buyer's agents, when you're at settlement with the closing attorney, there's a really good chance they're going to hand you the key. Here you go. You need to keep that key securely in your pocket until you get that email that says, we are on record. And there's a chance your buyer will look at you and say, oh, just give me the key. I promise I won't go over until. What does the contract say? All means of access are delivered at closing. So we need to make sure. Buyers, congratulations, you signed. The next step, once I hear from the attorney that it's recorded, you and I will meet up whenever, wherever, so I can give you the key to your brand new home. Y'all don't trust those buyers when they say, I promise I won't go over. There's an old saying, y'all, in this industry, buyers are liars and sellers are too. So don't believe them. Don't give them access. Don't trust them. Because guys, think about it. The property until closing, until that deed's recording is still on the seller. So if the buyer goes over to their new home that's not theirs yet, walks in the front door, falls down and hurts themselves, the risk of loss, the risk is still on the seller. So don't put that temptation out there. Everybody good with that? Buyers don't like this. So I think sometimes having conversations ahead of time. Hey guys, we're going to closing next week. So let's talk about what this means and when you're going to get your key. Set the expectations up front so they're not expecting it at the attorney's office. Other means of possession. We may have an opportunity to do a buyer possession before closing. We may have an opportunity to do a seller possession after closing. I got forms for both. We'll see those tomorrow. But in either case, either the buyer's moving in before the deed is recorded with consent of the seller through this form, or the seller is staying after the deed is recorded with the consent via this form. In either situation, one party's acting as the landlord, the other party's acting as the tenant. So the forms address basic short-term lease items. Again, we'll see all that tomorrow. Our third option here is if the buyer's already there. So if a tenant's doing a lease to own, they already have possession. And again, we got our additional provisions addendum or our vacation rental act. So scattered throughout the contract, when a need comes up to use an addenda, the contract lets us know. Thank you, Forms Committee. That's a feature I like a whole lot. In addition to that, provision 14, we have a nice little handy dandy checklist to make sure that we have all addenda that apply to this transaction. Most of these forms we will look at or discuss tomorrow night, not word for word, but just get a very basic understanding of what each one does. Just make sure you look at this, you review this, and make sure that you always include any applicable addenda. Because if you don't add them, then they are not part of the contract. So addenda adds to and becomes part of the offer, and upon acceptance, the contract. The blue note, all in bold, under North Carolina law, real estate brokers are not permitted to draft addenda to this contract. So I like that they put that in there. So a buyer can't look at us and say, can't you just draft this up? Nope. Assignments. We defined an assignment. All the terms stay the same. The only thing that changes is the names of one of the parties. And contracts should spell out whether or not they can be assigned. So specifically 2T says this contract may not be assigned without the written consent of all parties. So technically speaking, we could assign this contract as long as we have written consent by all parties. I would say at least talk to your BIC, if not an attorney, before we start assigning contracts. Start with your BIC. Almost always a good place to start. Tax deferred exchange is an IRS program. What is it? The 1031 exchange, I think it is. Yep. So the 1031 exchange, what the tax deferred exchange does, the investor can sell this investment property. And if they use the proceeds of the sale from this investment property to purchase another investment property, then they can defer paying taxes from the one that they sold. This is a great IRS program for your investors. If you're an investor or if you're working for investors, have them talk to their accountants to make sure that they take advantage of this, because there are rules with the 1031 exchange. So you can keep deferring paying those taxes, those capital gains taxes, as long as you are exchanging an investment property for an investment property. So in the event the buyer or seller desires to effect a tax deferred exchange, buyer and seller agree to cooperate in effecting such exchange, provided that the exchanging party shall be responsible for all additional costs, provided further that the non-exchanging party should not assume any additional liability. Buyer and seller shall execute additional documents, whatever we need to for the exchange, as shall be required. Tax deferred exchange, this is call your accountant. The others or another CYA. Call your attorney, call your accountant. The rest of the contract is pretty much boilerplate stuff. Boilerplate means it's standard. You can expect to kind of see this verbiage in most sales contracts. There's a couple things here that I do want to point out that we've discussed. The parties to the contract shall be binding upon and shall in order to the benefit of the buyer and the seller and their respective heirs. When do heirs kick in? When the individual passes away. Remember, death is only an out when you're negotiating the offer. Once you're under contract, if the individual passes away, buyer or seller passes away, weren't their intentions to buy or sell pretty clear? Don't we have a bona fide legitimate contract showing their intentions? So their heirs are expected to carry through with their intentions. And if they can't or won't, then they suffer the consequences of breach that we will see below. Other good stuff. Entire agreement. This contract contains the entire agreement of the parties. There are no representations, inducements, or other provisions other than those expressed herein. So all agreed upon terms, everything about the contract is here. Any changes, additions, or deletions must be in writing and signed by all parties. Nothing about anything that could affect our agency agreement. So remember, our agency agreements discuss our commission. Our commission doesn't belong in the sales contract. Stay tuned on that. Keep your ears open because that very well may change with this NAR settlement thing. There's lots of noise out there right now. So just stay tuned, current, whatever's coming down from NAR. This agreement shall not be recorded without the express written consent of buyer and sellers. There was, during this crazy seller's market of the pandemic, there were buyers that were recording the sales contract to lock down the sellers. You can't sell it to anybody else because when the attorney does the title search, they're going to find a contract. Kind of a shady move. So they added this saying you can't record it unless we have written consent of both parties. Conduct of the transaction. Parties agree that any action between them relating to this transaction may be conducted by electronic means. So remember, our UETA says we have to have permission. So not only do you get it in the terms and services of .loop, for example, we also address it in the contract that this might be electronic means. However, we want to be communicated is addressed below in the notice information. Any of our fees or deposits can be delivered to the party's agents. So you and I can play delivery man in getting the due diligence fee or the earnest money deposit where it needs to go. We have permission to do so here. The other thing that this is saying, the last 2 pages of the contract that we'll look at are not actually part of the legally binding agreement. We are going to see in just a second where the parties sign. Where the parties sign is technically speaking the end of the contract. The last 2 pages are supplemental, meant to help with the transaction, meant to help. But they're not legally binding. They're not what makes or breaks the contract. Execution, it could be signed in its multiple originals or counterparts altogether, which constitutes one and the same. Computation of days, the contract tells us how to count days. So for purposes of this contract, days are any consecutive calendar days that include Saturday, Sunday, and holidays. In contract world, when you're counting days, a day is a day is a day. TRID says Sunday and holidays don't count. The contract says it does. So we just need to know what we're counting days for. Calculating days shall begin on the day following any act or notice is provided following receipt or execution. And then any reference to date or time in this contract, such as 5 p.m., is going to be whatever time it is in North Carolina. In other words, Eastern Standard Time. I remember when this was added many years ago, because there was somebody out in California signing a document. Said you signed it late. Guy in California said, I'm on Pacific time. I signed it on time. It turned into a thing. Now the contract says Eastern Standard Time to avoid any confusion. So when we say 5 p.m., that's our time. These things are here for a reason. All right, paragraph 23, remedies. Once upon a time ago, remedies were scattered all throughout. It's one of those things that you had to search for. It was addressed in several different places. Several years ago, the Forms Committee put it in one nice, neat package for it. I can't tell you how much I appreciate that. If I were to critique anything, I hate that they put it at the end, buried amongst all the boilerplate stuff. I wish they had it closer for us. So please make a note. The remedies are addressed or spelled out in paragraph 23. So first, let's talk about breach by the buyer. Please understand, you guys, the buyer's not in breach until they terminate after due diligence. That due diligence is their easy exit period. That due diligence is what they paid for their right to terminate. So the buyer's not in breach until after 501 on the due diligence date. Do I have everybody so far? Otherwise, they've just exercised their right to terminate. So we are after due diligence. In the event of material breach of this contract by the buyer, the seller shall be entitled to any earnest money deposit. The payment of the earnest money deposit and the due diligence fee to the seller together shall serve as the seller's liquidated damages. We talked about liquidated damages last week with our money damages. Liquidated damages are contract money remedy damages that we agree to at the time of contract formation. Aren't we negotiating the amount of the due diligence fee? Aren't we negotiating the amount of the earnest money deposit? We got to have both parties agree. And if the buyer breaches the seller's liquidated damages, they will keep the due diligence fee. And now they're going to get the earnest money deposit. These liquidated damages serve as the seller's sole and exclusive remedy, which means this is all they get. If the buyer breaches, the seller can't go after them. The judge is going to pick this contract up and say, it says right here, you get the earnest money, you get the due diligence, and that's it. So listing agents, as those due diligence fees and earnest money amounts are coming down, they're no longer 5 digits. I don't know that they're still reasonable, but they're more reasonable than what they were a couple years ago. As we make that shift more and more into a buyer's market, we're going to see those fees come down. And listing agents, I need you to make sure that your sellers are good with these amounts, because that's all they get. Y'all think about it. We're close to closing at this point, aren't we? We're past due diligence. We are a week or two, maybe a day away from settlement. The seller has made arrangements to live somewhere else. Maybe they've entered into a sales contract to purchase a property. Maybe they've signed a lease. They got to go somewhere. We're not trying to get a roommate here, right? They've got to go somewhere. And we got to ask them, if you have to break your lease, if you have to break your sales contract, are these liquidated damages sufficient to cover those costs? A common question comes up. What if the buyer breaches, but the seller already did the repairs? The buyer asked the seller to fix this, this, and this, and the seller said, yeah, sure, I'll do it. They fixed it, they paid for it, and then the buyer breaches. Can the seller go after the buyer for the cost of those repairs? And the answer is no. Sole and exclusive remedy. But consider this, when the seller puts their home back on the market, they're putting a better product on, because now they're putting a home on the market that doesn't have this, this, and this issue. So can't we adjust the listing price? And can't we advertise? The seller just fixed all the electrical. The seller just addressed the plumbing. They can't go after the buyer, but we can't advertise and promote that. We can adjust the listing price when they put it back on the market. None of this addresses, again, we saw several places where where the buyer may get their due diligence back. So this is just reminding us where that was. Failure to get the RPOs, the governmental compliance things, dishonored funds. There's a couple places, so that helps address us to that. The liquidated damages is compensatory and not punitive. Such amount being a reasonable estimation of the loss that the seller would incur as a result of the breach of the contract by the buyer. The payment to the seller of the liquidated damages does not constitute a penalty or a forfeiture of actual compensation. Both parties acknowledge the difficulty of determining the seller's actual damages. Again, real estate's a market. I always think of real estate, it's on a pendulum. We go from a seller's market to a buyer's market, and that pendulum is constantly swinging, probably not this fast. Sometimes it feels like it, but that pendulum is constantly swinging. And y'all, a couple of years ago, that seller's market was like way up here. We're still in a seller's market, not as strong, but we are still in a seller's market. And one day, I don't know when, but one day we're going to shift back to a buyer's market. The last buyer's market we were in, I remember due diligence fees of $50. Is that enough for your seller to break their lease? Is that enough for their seller? So we just need to help them negotiate, help them decide which amounts are best for them. $50 generally isn't going to cover it. That's all the seller gets. Do I have any questions on breach by the buyer? So what happens if the seller breaches? In the event, if the seller breaches on day one or settlement and in between, they have no easy exit. They have no due diligence period. That due diligence period is only for the buyer. So in the event of material breach of this contract by the seller, the buyer's got some choices. The seller breaches, the buyer can elect to terminate this contract. They shall be entitled to their earnest money deposit and their due diligence fee, along with reasonable costs incurred by the buyer as part of their due diligence costs. Again, when we were talking about money damages, we talked about compensatory damages. Compensatory damages are those money damages that you can prove with receipts and invoices. Can the buyer prove that they paid the earnest money deposit? Can they prove that they paid the due diligence? Can they prove that they paid for the appraisal, the survey, the home inspector, or at least had those performed? Those are the things, if the buyer terminates, that compensatory damages is what the buyer can go after the seller for. If the seller's not willing to sit down and write a check, then the buyer can take them to court. The whole thinking here is that the seller never agreed to contract with the buyer would have never spent this money. They would have never ordered an appraisal. They would have never had the home inspection done. They wouldn't have had a survey. But because the seller breached, the buyer wants to be made whole. And that's what compensatory damages does. We're not going above and beyond for pain and suffering. We're just trying to make the buyer whole if they elect to terminate. Their other option, if they elect not to terminate, they can treat this contract as remaining in full force and go after the seller for specific performance. Another contract remedy we discussed. If the buyer goes after the seller for specific performance and the buyer wins, the judge can make the seller perform as promised. In other words, the judge can make the seller sell. That's their performance under this contract. Now, there's a big difference in can't sell versus I've changed my mind. If they change their mind, specific performance might be an option. But what if they can't sell? What if it's an estate and one of the siblings are refusing to sign? Nothing we can do. What if we have that long lost uncle? Breach by the seller. This is what I know about it. If your buyer wants to get into specifics, we may need to advise them to talk to their attorney. I think we can agree that breach by the seller is much more harsh than breach by the buyer. If the buyer breaches, and whatever, they lose earnest money and due diligence, and that's it. If the seller breaches, the buyer can sue the pants off of them. The reason being, you guys, it's much harsher for the seller because the sellers initiated this whole dang thing to begin with by putting a for sale sign in their yard. They started this chain of events that got us here. And then we address legal or attorney's fees. If legal proceedings are brought on by either party against the other to collect earnest money, due diligence costs, parties agree that a party shall be entitled to recover reasonable attorney's fees to the extent under this North Carolina law. Let's see, the parties acknowledge and agree the terms of this contract with respect to those fees each constitutes evidence of indebtedness, again, under this North Carolina general statute. I believe basically what we're saying here, again, the contract's pretty clear about what happens if either party breaches. But if the breaching party isn't willing or able to perform, then the non-breaching party may take them to court. The judge will pick the contract up and say, well, this is what the contract says. You owe this person. And not only will the breaching party have to pay per the contract, they're also going to pick up their own attorney's fees, and they're going to pick up the other party's attorney's fees. Nobody likes to terminate. And sometimes we just need to let everything settle, let the dust settle. Sometimes things look much better in the light of day. And if your parties are digging their heels in, pull this out and read it to them, have them talk to their attorney. Nobody wants to go to court. So maybe once everybody's emotions calm down, it's tough when we have to terminate. But that's why we have a contract. Questions on any of our remedies? Blue note says a party seeking recovery of attorney's fees under this North Carolina general statute must first give written notice to the other party that they have 5 days from the mailing of the notice to pay that outstanding amount without attorney's fees. So again, we're just addressing what happens if we have to go to court. All caps. This makes me giggle. the North Carolina Association of Realtors and the North Carolina Bar Association, remember, those are the people that wrote this thing, make no representation as to the legal validity or adequacy of any provision of this form in any specific transaction. Isn't that nice? If you do not understand this form or feel that it does not provide for your legal needs, you should consult with a North Carolina real estate attorney before you sign. Once you sign and we have communication of that signing, communication of acceptance, it's too late. Offer is going to become a binding contract on the effective date. Unless specifically provided otherwise, buyer's failure to timely deliver any fee, deposit, or other payment shall not prevent this offer from becoming a binding contract, provided that any such failure shall give the seller certain rights to terminate as described herein or otherwise permitted by law. And then we have a place for the parties to sign. This marks the official end of the contract. Where the parties sign is officially the end of the legally binding contract. You can see I got a place for 2 buyers and 2 sellers. If you have more than 2 buyers or you have more than 2 sellers, we have a form for that. And it's called the Additional Signatures Addendum. The Additional Signatures Addendum gives me a place for 8 more parties to sign